there any deputies at North Broward?
Morning, Your Honor.
Hi, do you have everybody ready, or?
Yes.
Okay, all right, Mr. Farberick will be calling them in a moment, okay?
Okay.
Thank you.
do a search on 18841.
On Odyssey?
Yeah, because we're going to see when he was arrested on that to see if this violates, if this
Is
case.
it under case?
Yeah, 18.
18, Mike.
Okay, good morning, everybody. My name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today you will be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial date. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. You also have a right to an attorney. There's a public defender, Mr. Romero, who's at the main jail, and I have Mr. Barbaric, who's here in the courtroom with me. If you have a private attorney, when you step up to the podium, please let me know. Thank you. Okay, we're going to take one out of turn. I believe there's a private attorney here this morning. Good morning.
Good morning.
Brandon Gaines, state, announce your appearance, and then Mr. Gaines is attorney.
Eric Linder on behalf of the state.
Judge, for the record, Stephen Sessa.
Good morning.
Good morning, Judge.
How are you?
I'm just fine.
Okay. All right, sir, Mr. Gaines, you are charged with aggravated battery, bodily harm, or disfigurement. We need to talk about bond.
Oh, it's
And
not
then
true.
count 2 is criminal mischief to between $200 and $1,000 first offense. Court does find probable cause unless I hear an argument.
Judge, no, not at this time. I have spoken to the state, and we've agreed to a $15,000 bond and no contact with the victim.
Okay.
And Judge, just to be clear, is that 15 going to be split or 15 on the aggravated battery and OR
It
and
was
the
going to be,
criminal mischief?
well, I mean, all right, I'm fine with the ROR and the criminal mischief. It's 15,000 on the aggravated battery.
15, right?
Yes.
Okay.
Scroll down.
Is this the bail bonds case?
Yes.
Yes, ma'am.
Now you see what all the other, now you see how there's 1 through 21, score keeps rolling. And that's everything else is being held on. So you can let the court know about all the other stuff is being held on when this case comes up. Now, have you given, when you were going through these cases, see, like, you're gonna have to recommend a bond on that. Have you given any thought to that?
Hey, what's the victim's initials?
So it is, they are AH.
Okay, sir, there's going to be no victim contact, direct or indirect. That means no calling, texting, in person, anything on
Scroll down.
social
You see-
media,
see
liking,
21.
disliking, or through third parties. Do you understand? It's with AH.
That was yesterday.
Judge, I think he understands that. I do believe that the victim in this case is in custody of the Palm Beach County Sheriff, and he's looking to go to prison, so
Okay, all right,
just for information.
okay. All right, so this is what the court's going to do.
So I think that's a good way to go for that.
You want me to do 14, 5, and 5? Or you want me to just do 15 and ROR?
15 ROR is fine, Judge.
Okay, and that's with the agreement of the state?
For these, yes, so you're just gonna, so for some of that, you wanna get in the back of your head, but you maybe, so. They're mixed up. I have some of the guys, if, when we get to the male felonies, if she calls a case and you don't have it, it's because I've got it.
Okay, counsel, if you could approach just
Ye-
for one moment.
Yes, ma'am.
All right, sir,
You can keep them
so,
up there.
$15,000 bond, no victim contact, direct or indirect, with the alleged victim with the initials AH, okay? Good luck to you, sir.
Thank you, Judge.
Thank you.
It's
Nice
connected to
seeing
that
you.
printer.
All right, next one is gonna be Damian Alexander Vale.
Mr. Vale, your present, Judge, at Maine?
Okay, good morning, Mr. Vale. You have 4 out-of-state hold
So you could
felonies.
What I would do,
Appears are all from Colorado,
just, put it on the bottom.
so you're gonna be held no bond. I guess I'll see you, sir, in extradition court either tomorrow or Tuesday, okay? Good luck to you, sir.
Right, sir.
Next one's gonna be Joseph Donathan Tharp, please.
Mr. Tharp is approaching, you're in custody?
Who do you have? Did you get his name, Willie? Okay.
You don't have any
take
of
your
these.
time. Joseph Donathan
We're not getting to use
Tharp.
yours for a little bit. So.
Okay, okay, Mr. Tharp.
what's
Morning,
that?
Mr.
Yeah,
Romero,
you
how
got
are
some.
you?
Good morning, Judge.
What
Okay,
can do
you
if
have an
want to.
out-of-state hold from Georgia
Well, here's what you
for
can do.
aggravated assault.
So rewind it a second.
We will see you in extradition court either tomorrow or on Tuesday,
If
okay,
you
sir?
want,
Good luck.
if you want to, if you have an idea what you want to ask for bond, here, take these post-its and
There's
write
no
down
bond,
post-it.
right? Yes. Okay, just wanted to double check. All right, Linda Morgan, please.
North Broward, Judge.
Hello, Miss Morgan, how are you?
Well, I'm here, so I guess
Sorry
Okay,
about
great.
that. Sorry.
I understand. All right, ma'am, you have a capias for unlawful assembly. It was issued March 1st, 2018. You want to resolve your case today?
I'll save you some time later.
yes, I would like that immensely.
Okay. All right, ma'am, raise your right hand. Do you swear and/or affirm
He
to
has
tell the truth?
juveniles.
I certainly do.
Okay, your name is
Yeah,
Linda
exactly.
Morgan, M-O-R-G-A-N.
It's Federal Judge Linda K. Morgan, Bureau of Prisons President. Yes, it does.
Okay, that's your name?
Yes, it is.
Judge, this is also a municipal ordinance.
He had a felony out of Palm Beach for marijuana.
Okay, ma'am, let me ask you a question. It's my understanding you wish to waive your right to a trial and an attorney?
She has a better
Resisting without.
I'm sorry, I did what?
It's my understanding you wish to give up your right to a trial and an attorney?
Domestic violence battery.
Well, no, if that's what it takes, then that's what it takes, because this officer, this is twice now that he's come after me.
All right, don't talk about the facts of your case, though. So, let me ask you this. Have you ever been treated for a mental illness?
Absolutely not.
From pretrial, someone from pretrial will be here, and they can also check for felony priors also.
I work with the Justice Department out of Washington, D.C.
Okay.
It's not,
All right, you know what, ma'am? We're gonna pass your case. Let me just, I'll tell you what, let's transfer this to Lerner Wren.
I know, but I still got a text.
Eric?
I will, yes, Judge.
Okay, thank you. All right, ma'am, you're gonna see a different judge, yes, tomorrow. Her name is Judge Lerner Wren, okay?
Let me see that traffic. and
You'll
cannabis,
see her
please.
tomorrow, ma'am. Good luck to you.
thank you.
You're welcome. Sure. Spell? Okay, N-A-N.
It's a
Wheat.
subdivision.
Wheat.
Let me just see if I have his paperwork. N-A, what's his first name?
First name is Dan Kumar.
Page 10, it's a VOP.
It says Sentinel Division, but they called him, and like I said, it's a different contact.
Sure.
Okay, so call his name.
He's gonna go to
Right. I didn't want to tell the deputy at Conti to send him back, but he has them. That's the only reason I'm calling it.
All right,
Oh, yeah,
you
well,
wanna
that's up
call
to
him
you.
because I don't have him.
Sure.
Yeah, I think it's reasonable.
Um,
What do you think?
Call the case.
Mr. Tularam?
Yeah, that's me.
He's got the
Yeah, I
kids.
Well, I
don't know
thought you said
anything
it's
about this.
NAN. You're saying
The first name is Nan Kumar
Yeah, so
Tularam.
you should ask for the
Okay,
increase.
what name is that by?
Bell, it's in front of Bell. It's one of the first few, it looks like one of the first few felony mails. Maybe the second felony mail, first felony mail.
Okay, I have Bell, and then I have Rosengarten.
And the one in front of Bell?
Isaiah Brian Barfield.
Yeah, they pulled his stuff is a division, so he can,
Okay, where's he supposed to go?
y-
You released me yesterday. I don't understand why is this popping up today.
yeah, not,
Hold on,
Yesterday,
sir.
this wasn't here. This wasn't here.
what I'm showing, this is, what I'm showing,
Somebody using my name out there, and I'm getting charged while I'm in here. I have a 2-year-old that they gotta take care of. I'm a single father with a 2-year-old, and I'm in jail, which I've been stabbed 2 months ago, still freshly healing. Look up here, I've been stabbed in my heart, I've been stabbed in my stomach. I'm taking care of my 2-year-old, and I'm in jail, which nobody can take care of.
sure, so what I'm showing, and for the court, what I'm showing is this is an ad, it looks like an ad count 5, it's a violation of
Hold on, sir.
probation.
He's trying to explain it to you. Just relax.
It looks like a violation of probation that was added from a 2016 case. The paperwork apparently was sent to the division. The only reason I called it is because the deputy indicated that he had pulled him for this morning's magistrate, but he's not on our docket. Technically, it was removed from the docket.
All right, so where is he going?
That I'm not sure.
Eric, can you enlighten us?
I should let my
Sir,
kids starve
hold,
out there?
sir, we're trying to resolve it. I'll let you talk, don't worry. Eric from the state
Your
attorney's
Honor,
office, go ahead.
I'm looking, Your Honor.
Judge right here is looking,
Thank you.
Sure.
he's gonna be moved over to the division judge. Apparently Conti's the final docket, and that's why they pulled him from magistrate, but on the final docket, he is to be set in division, and he was violated for the probation because he received the new,
What judge is it?
Judge Siegel.
offense.
All right, so Conti, deputy, what time was he supposed to be there this morning?
I don't know.
That, I don't know
He was
what time they
supposed to
have
be
him
in the main,
scheduled for.
I mean, at, Judge Siegel this morning over in the West Wing.
I mean,
There was a final docket, so, but we're trying to figure something out for him. Mr. Linder's looking.
Okay.
This is your only person for today, right?
Well, Your Honor,
For now?
I don't know what he's assigned to Judge Siegel. I don't know what else.
Does it have what it's for, though, or
It's based on Your Honor,
DOP?
he's on probation. He was arrested on March 30th for theft and I'm sorry, one moment, Your Honor. He was arrested for DWLS and presenting non-current proof of insurance. Probable cause was found. That forms the basis of a violation of his probation.
Why wasn't it in the first sheet? If that violates,
I
that's
don't
supposed
know,
to be my
sir, but
first
you're gonna
charge.
have to take it up with Judge Siegel. So, I don't know, how do you get him over to Siegel or contact Judge Siegel's office? Maybe you can get him there this afternoon or this morning, I don't know.
I'll have to call intake and see what they could do, but he's on Judge Siegel's docket.
scheduling for he's gonna see Judge Siegel
This morning or this afternoon?
this afternoon.
This afternoon, Judge Siegel.
Okay.
All right, sir? You're gonna go before your division judge and be able to speak to the judge about it. Thank you, sir. Good luck to you.
Okay, thank you, ma'am.
Okay.
All right.
All right, so we have,
And if I can do one other one, Judge, I'm sorry.
Sure.
This gentleman indicated that he was supposed to
Just
go
tell
to
me
his,
the name first,
sure,
so I can
it's
start looking.
Tawan West. He's at North Broward,
what page?
page 18, top of 18.
Why do we need to do Mr. West?
The only reason I'm asking, Judge, is he indicated that he has a court date this morning on his violation of probation. And I don't know if we can get, if they will get him over there this morning for that.
Okay, where is he?
North Broward.
Good morning.
Good morning. Are you Mr. Twan West, sir?
Yes, ma'am.
All right, can I speak to a deputy at North Broward? Good morning, how are you?
Morning.
All right, so how do you handle it when he has a probation violation hearing? He's actually being held no bond, but he has a hearing this morning in front of Judge Michael Rothschild at 9 a.m.
Well, we'll have to get in contact with intake, and they'll have to send a transportation to take him.
Okay, all right, well, let me just magistrate him on these charges, and then maybe you can get in touch with intake, okay? Thank you. All right, sir, so you have a probation violation, no bond hold. You have driving while license is suspended, $750 bond. And then you have two matters for, not for magistrate court, which is just failure to provide proof of liability security and expired motor vehicle registration over 6 months, no bonds attached to that. So the court's gonna find probable cause. You're gonna be held no bond on the probation violation. And on the driving while license is suspended, the court will set your bond at $699, and they'll try to get you over to your division judge today, okay?
Okay, so my bond is only $699?
For the driving while license is suspended, however, the probation violation, you're gonna be held no bond, that's what you were going to court on, okay?
Thank you, ma'am.
You're welcome. Hopefully you'll go over to see Judge Rothschild today.
Thank you.
You're welcome. Okay, so,
They gotta quickly scan this if they're gonna bring him over there. And
there's Keisha Marie Cruz Torres we're gonna call, and then we have page 24, Garvin Wheat.
Judge Jeffrey Grossman on their behalf.
Hello,
I gave him back to you.
how are you, Mr. Grossman?
I'm good, Judge. How are you?
Fine, thanks. All right, so where is Keisha Marie Cruz Torres? Is she bonded?
Is your present judge of Maine?
They're in the process of bonding her, Judge.
Oh, you are?
From what I was told by her family. I think page 5 on Keisha.
Keisha Marie Cruz Torres, is that your name, ma'am?
Yes.
All right, counsel, if you could announce your appearance for the record and then state.
Jeffrey Grossman on behalf of Ms. Cruz.
State.
Eric Linder on behalf of the state.
Is there a probable cause argument?
It's almost impossible to read the PC, Judge. However, best I can
I
tell
don't
is
see a test on here or anything.
It says on the 1, 2, 3, 4, 5th sentence down in the middle, the cannabis and the products, it says FTP for field test positive.
And weighed approximately 70 pounds. All right.
Yes.
All right, so the court is going to find probable cause. Mr. Grossman, bond set at $75,000. What say you?
sounds like a bit much. Does she have a record, Judge, priors?
State.
Your Honor, I'm going to be asking that the $75,000 bond be kept in place. She has no criminal history, but even with no criminal history, if she is convicted of this offense, she faces a 3-year minimum mandatory prison sentence. I would also note the amount of drugs, as you stated, approximately 70 pounds was located in the apartment.
Judge, we have nowhere.
And this is between 25 pounds and 2,000 pounds.
Yes, ma'am.
Okay.
Judge, we're unaware of where this was found. There were more than one person in the apartment. We don't know who owned it.
Your Honor, it clearly states.
It's not clearly on mine, I'm sorry. I just couldn't read it.
Okay, this
Clearly
is what it
states in my
says.
copy
On the
that was that I.
Update in time, and I'm paraphrasing. Search warrant upon making entry, contact was made with Cruz Torres and co-defendant Wheat, who were the sole adult occupants. Search of the residence revealed several bags and packages of cannabis, THC edibles, and THC. Most items were in plain view and in the open, very visible. The cannabis, THC products, FTP, field tested positive and weighed approximately 70 pounds. Cruz Torres provided a statement acknowledging she was aware of the cannabis and THC.
Where, but not the owner of, Judge.
She used the products.
And Your Honor, I would also note that both co-defendants, their permanent address is listed in the report, is identical to the residence that was searched.
Okay.
That doesn't mean they own it, Judge.
Okay, so what are you asking for? Or
A lower
what do you-
bond,
Okay, what are you asking for?
somewhere in the neighborhood of 10 to 20,000.
Okay, $25,000 bond. Thank you.
That's with regard to Cruz Torres, right, Judge?
Yes. Next one is wheat.
I believe Garvin's on a VOP, no bond hold,
Yes.
so he'd have to go see, I believe it's Judge Usan.
Okay, Counselor, if you can announce your appearance again.
Jeffrey Grossman on behalf of Mr. Wheat.
Okay, we're calling Garvin Darrell Wheat, state announcer appearance.
Inez Goncalves on behalf of the state.
Hello. All right, so we have count one, search trafficking cannabis between 25 and 2,000 pounds. You had approximately, I think they said 70 pounds. Is that what it was? Is that what I said, 70?
And I'm unable to read my copy, Judge. But I believe it will be similar facts. I don't believe that there's any admissions, as best as I could tell from reading this particular PC. And again, there's the issue of more than one adult. Neither one had any of this on their possession.
Do it, so you know.
Just to let you know, this PC says, I didn't see it in the other one, although I could have missed it. The search also revealed several firearms in the garage and master bedroom. Weed is a convicted felon, currently on felony probation. Okay. So, sir, you have a charge of trafficking cannabis, $75,000 bond is what we have. We're going to talk about in a moment. Then we have possession or weapon or ammo by a convicted Florida felon. And then we have count 3, grand theft of a firearm, $1,000 bond. And count 4 is a probation violation. I can tell you, you are going before your division judge this Monday at 9 a.m. You are going to be held no bond on that charge. It's Judge Usan, Michael Usan. So the court does find probable cause unless I hear an objection.
Judge, again, the same objections. There's no indication that he had any of this on his possession. There's more than one adult in the house. There's no indication he's an owner of the house.
Okay.
Judge, the address listed on the PC is the same address in which the drugs are found, and the drugs are found in plain view. And the state would ask that the bond remains.
Okay.
Certainly the gun wasn't found. I think that, didn't you, Judge, just say it was found in the garage or something?
The search also revealed several firearms in the garage and master bedroom. Okay, so state.
One moment, Your Honor. Well, Your Honor, there can also be argued, as there's constructive possession of the drugs, there could be constructive possession of the firearm. The difference being that Ms. Cruz Torres is not a convicted felon, so she can legally be in possession of that firearm, whereas Mr. Wheat cannot.
Okay, so
So we'd argue for PC for,
no PC for 2.
well,
You want 24 hours to
well,
perfect?
why is there no PC
Well,
for
it could have
that?
been her gun.
Yeah, but Your Honor, just like the drugs, it could be constructive possession. He's not. It's out in the open.
No, there's no indication it's out in the open. Just said they were found in a bedroom, could have been a locked box. Who knows where they were found in the bedroom? I don't think the PC said those are in plain view.
Okay, that's fine. I'd ask for 24 hours on 2 and 3, Your Honor. I'm sorry. So there's nothing, there's no reports on that.
Okay, we're gonna do it. Are you gonna be around tomorrow morning?
Chair every day, Judge.
Okay, I just didn't know if you had to be in Palm Beach or Miami or something.
I'll make myself available, Judge.
All right, so we'll do it on the morning docket, and we'll try to take you first, okay?
Thank you, I appreciate it.
Or if you want, usually Thursday's a heavy day, so,
Thursday's a very heavy day, but I'll be here.
okay. All right, so no PC on 2 and 3. State, let's talk about a bond temporarily. I am gonna set a bond even though he has a no bond hold.
All right, one moment, Your Honor. So what do you?
On 2. 3, we don't need to.
The state would ask for $10,000 on count 2.
Which one was count 2? Again, I just hard to read this,
Possession of-
Judge.
I know, it's very hard. I'm gonna talk to the clerk's office about it. It's possession of weapon or ammo by a convicted Florida felon.
That's the one you just found no PC on.
Yep, but right now, there's no bond set, so I can leave it as no bond till tomorrow. It's up to you. And we can readdress it tomorrow as well.
Why don't we address it tomorrow? He's not going out today. He's got no bond
Okay,
hold
so
anyway.
we'll wait. All right, so count 1 is the $75,000 bond. Want to say anything?
No, I'm not saying it's your fault.
Okay, trafficking cannabis, $75,000 bond. Let's address it now, sir.
For the same arguments we'd make on the previous, we'd suggest a lower bond in this case as well. Again, there's been no proof that this is a house he owned. Nothing was found on him. So it's constructive possession at best. We request the same bond as the previous case.
Okay, this is what the court's gonna do. On count 1, court's gonna do $25,000. However, court is gonna do a GPS open schedule that's based on he is on probation. He does have a hearing this Monday, April 9th, in front of Judge Usan at 9 a.m.
Your Honor,
Address the no bond. Yes?
state would oppose an open schedule based on the amounts that were found, and considering he's on probation, there's reason to believe that Mr. Weed may be involved in drug dealing, and based on that, I think it's reasonable to have him on a schedule where pretrial knows where he is. If he's not, then, and if he is involved in drug dealing, he would technically be able to go around the Tri-County area continuing dealing because he can go anywhere he wants at any time.
All right, that's fine. Open schedule. Thank you.
What? Okay, so
I-
you're
over your
denying,
object-
okay.
Yes, I am denying it. Open schedule. Thank you.
Thank you, Judge. We'll be here tomorrow morning.
Sorry, 25,000.
Yes.
Right.
Yes.
State requested
Hold on a
$75,000
moment.
bond.
On here.
No,
On 2,
at the
right?
bottom here.
Oh.
Here, no, okay.
Yes.
Remember, 25,000. PC, no PC.
Yes.
Okay.
But we're gonna keep
then
the
up
$1,000
here,
bond,
right, state requested
$1,000 on count
75,000.
3. Count 2, the attorney didn't wanna set it. He didn't wanna talk about it. Yeah, thank you.
Thank you,
Okay,
Judge.
Thank you.
I'll see you tomorrow morning.
Okay. Natasha Antoinette May, you have a case. Let me just
Parentheses,
take
open
this one and then
schedule.
we'll get to
You
you.
can write PTR. just-
Natasha
please look at the
Antoinette
same
May,
time.
please.
No problem, Your Honor.
Wait, no. Pretrial release
Okay,
GPS, no.
Ms. May,
no,
good
I'm saying
morning. You
for pretrial,
have
you
a
can write
possession
PTR.
of drug paraphernalia. What are we doing with this, folks?
Schedule.
Judge, she wanted to know, I spoke to her this morning, she wanted to know if she could resolve the case today.
State,
Adjudication time served. And under that, right, state requested level 2.
does she want it?
Judge, she wanted to try to resolve it, yes.
Okay. Ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Latasha May, M-A-Y?
Yes, ma'am.
You want to resolve your possession of drug paraphernalia case today for adjudication and time served?
Yes, ma'am.
Realize I have to impose court costs by law, $293? Yes,
money.
I understand, but I have to impose court costs nonetheless. Thank you.
Yes, ma'am.
All right, ma'am, so you wish to waive your right to a trial? Want to give up?
mean?
That means, do you want to give up your right to a trial and plead guilty or no contest, or do you want to have a trial?
I don't know.
Judge, when I spoke to her this morning, she indicated, I asked her for some background information. I asked her if she wanted to try to resolve the case and be done with it today, and she indicated that she did. Is that correct, ma'am? You can fight these charges and come back to court, or you can try to resolve it today so you don't have to come back to court. It's up to you, whatever you want to do.
I was sorry today.
Okay, so then you want to give up your right to have a trial then?
Yes.
Okay. Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or
No, ma'am.
medication? Let me finish. That would affect your ability to understand what's going on here today?
Yes.
You are?
No.
Okay. Ever been treated for a mental illness?
Yes.
Don't tell me what it is. Does your mental illness affect your ability to understand the nature of these proceedings today?
Yes.
It does? Okay.
Judge, in light of her responses, she may be a candidate to go to Judge Luna Wren.
Why don't you speak to her? Or you did speak to her and that's what you're recommending?
I did speak to her, and that's what I would recommend.
Okay.
She's able to answer the questions, but I do believe she's confused.
Okay. All right, ma'am, so you have a $500 bond. We're gonna transfer you to Judge Lerner Wren. And she'll be better able to assist you, ma'am, okay?
Yes, ma'am.
Thank you. Good luck to you, ma'am.
Okay, thank you.
All right, who do we have for the Spanish interpreter, please?
I think
Last is Justo at North Brown.
What is it, Jay?
on page 12, top of page 12,
Give
the
me the full name?
first name is Justo, Justo. Last name is Lassus.
Okay, hold on.
What's this thing with violence? What do you think?
Page 12.
I'm by Rosengarten,
what do you think?
Livingston, Jacobs,
Um,
Lasses, Quigg, Roundtree,
He would be after that.
Joshua
Well, you can just,
Jones,
I'm fine.
Approximately 4 people after Rose Garden.
Telemac, Laguerre,
Just got off
McRae,
probation.
Turpin,
Yeah. No,
Waldrop,
the enhanced was no.
Milton Grant.
No. He's after Jacobs, Livingston. He's after those
The
two.
enhanced was no.
Lingley, Ziegler, McInnes,
He would be roughly the 6th person in the male felonies.
give me the name again, the full name.
Justo Juan Lassus.
Spell the last name.
Lassus.
Okay. Who else do we have for the Spanish?
That was the only one that I'm aware of.
Mr. Romero, anyone else?
No one I mean today, Judge.
Okay, thank you. All right, all right. Raise your right hand. Do you swear and or
Just
affirm to
got
tell
off
the truth?
probation.
I do.
July
Okay,
last
state your
year.
first and last name. And spell your last name for the record.
Esteban Rojas, Rojas.
Okay.
So, what do you think?
All right, is your name Mr. Justo Juan Lazos?
Usted es el señor Justo Juan Lazos.
Yes.
Yes.
Okay, sir, you're charged with DUI, alcohol, or drugs, second offense.
Bien, señora, usted se le acusa de conducir bajo la influencia de drogas o alcohol. Es su segunda infracción.
$1,000 bond.
$1,000 de fianza.
Next one is DUI with damage to property of person or another.
Siguiente cargo es también DUI con daños a la propiedad en la persona o la propiedad de otro.
$1,000 bond.
$1,000 de fianza.
Count 3 and 4, we need to talk about bond, and you're being charged with.
Los cargos 3 y 4 tenemos que hablar sobre el tema de la fianza. Está siendo acusado de.
Count 3 is the same thing as 2.
Tercer cargo es el mismo que el
DUI with
2.
damage to property or person of another.
DUI con daños en la propiedad o en los bienes de otra persona.
Count 4 is resisting an officer or obstructing with violence.
El cuarto cargo es resistirse al arresto o obstruir la detención de parte del oficial con violencia.
Count 5 is reckless driving, first offense.
El quinto cargo es conducir de manera temeraria.
Count 6 is operating
Primera-
without a valid DL.
Primera infracción El
And
sexto cargo
7 is
es
leaving the scene of a crash involving damage to property.
operar un vehículo automotor sin licencia válida. El séptimo cargo es abandonar la escena de una colisión donde hay daños a la propiedad.
All right, state.
Fiscalía.
Judge, on count 3, the state would ask for $1,000, and on count 4, the state would also ask for $1,000.
Señora juez, para los cargos 3 y 4, respectivamente, la fiscalía solicitaría fianzas de $1,000 cada uno.
Okay, the court does find probable cause.
Consideramos que existen indicios probables de delito.
Defense, they're asking for $4,000 total in bond.
La defensa está solicitando un monto total de $4,000 de fianza.
Judge, I was unable to communicate with him. However, I'm going to ask through the interpreter if he's able to post a $4,000 bond.
Señora juez, el abogado defensor indica que no me fue posible hablar con el individuo, sin embargo, mediante el intérprete le pregunto, ¿es posible para usted, señor, pagar una fianza de $4,000 en total?
Or if his family can post a $400 bond through a bondsman.
¿O será que su familia puede pagar una fianza de $400 actuando mediante un agente de fianzas?
No creo.
I don't think so.
Is there any amount of bond that he would be able to post?
¿Hay algún monto económico de fianza que usted pudiera pagar? None.
Does he currently work?
¿Trabaja usted actualmente?
Actualmente no estaba trabajando.
At present, I was unemployed.
And does he have any money in the bank?
¿Tiene dinero en el banco?
No, tampoco.
No.
How long has he lived here in South Florida?
¿Cuánto tiempo tiene vivir acá en el sur de Florida?
10 años, 10, 11 años.
10, 11 years, something like that.
Okay. Judge, based on what he's indicated he can't afford any bond at this time.
Señora juez, con base en lo que ha indicado el individuo que dice que no puede pagar ningún monto de fianza en este momento,
He has been a resident here for over 10 years.
ha vivido en la zona durante más de 10 años.
I don't believe he presents a flight risk.
No creo que represente un riesgo de fuga.
I would ask the court if the court would consider RORing him to pretrial release.
Le pediría a la corte que considere la posibilidad de liberarlo bajo palabra durante el periodo de pendencia del juicio.
Judge, this is actually a second DUI, and the defendant just got off of probation July of last year, and this was a case in which he crashed into 2 cars.
Señora juez, esta es la segunda infracción del individuo y acaba más bien de salir de un periodo de probatoria en julio del año pasado, y este fue una colisión provocada por conducir bajo la influencia en donde golpeó a 2 vehículos.
We're gonna take you guys back as soon as we're done, okay? Give me a brown outside.
Okay, the court's going to keep the bond on counts 1 and 2 at $1,000.
La corte mantiene incólume la fianza para los el primero y segundo cargo, $1,000 cada uno.
Court will set bond at $500 on count 3 and 4.
$500 para los cargos 3 y 4.
Court is going to additionally put him on standard pretrial release.
Adicionalmente, se le imponen las condiciones de rigor para liberación o excarcelación previa juicio.
He's to have no alcohol or intoxicants.
No deberá consumir alcohol ni intoxicantes.
Random testing.
Pruebas aleatorias de drogas.
No victim contact, direct or indirect.
Se le prohíbe tener contacto directo o indirecto con él o las víctimas.
With the 2 alleged victims in this case.
Las 2 supuestas víctimas en este caso.
With the initials CC and MH.
Cuyas iniciales son CC y MH.
No contact, direct or indirect.
No deberá tener contacto directo o indirecto.
Means no contact in person.
Eso significa que no puede tener contacto ni en persona.
By any means on a cell phone, texting, calling.
Ni por medio alguno, por celular, mensajes de texto, llamada,
no emailing, no social media,
correos electrónicos, redes sociales,
no contact through third parties.
ni tampoco por medio de terceras personas.
Do you understand, sir?
¿Entiende, señor? I
Okay.
understand.
Thank you very much.
Bien,
Love you.
gracias.
Thank you.
¿Verdad?
Would you like to make an announcement for us, please?
I don't know why.
Thank you.
At the main,
Yes.
can they hear me over it?
Announcement.
Can they hear? Okay. ¿Alguna otra persona necesita traducción al español?
Anybody at North Broward? I guess there's nobody else? Spanish interpreter? Okay, anybody? Conti? Nobody. Thank you. Okay, anybody at Paul Ryan?
Not Spanish.
All right, thank you. Thank you so much for
Pleasure.
coming today. All right, Lizette Amy Diaz, please.
Yes, ma'am.
No problem.
All right, thank you. Ms. Diaz, you are charged with petty theft, first degree, between $100 and $300. Court does find probable cause.
Tell the court, I spoke with her this morning. She wanted to see if the court would possibly work this out.
State? Jackson, is there any way in the morning, I don't know who you could talk to, that could drop off an extra docket for us, because Michelle keeps them? All right, thank you.
State's offered being adjudication time served.
Adjudication, time served, $293. Does she want it? Okay, ma'am, they're offering you the state is requesting that you get an adjudication, time served, $293, and no victim contact with EC. Do you understand?
Yes.
Is that what you want to do?
Yes.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
I do.
All right, is your name Lizette Amy Diaz, D-I-A-Z?
Yes, ma'am.
It's my understanding you wish to give up your right to a trial, ma'am?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication, or ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No, ma'am.
You want to plead no contest to petty theft?
Yes, ma'am.
Realize that if you get if you get a third one, I don't know how many you have in the past, they can charge you as a felony.
No, I didn't know that, but I don't have any.
All right, so understanding that if you get two more of these, if this is your first one, that you can be charged as a felony, you still want to plead guilty or no contest to petty theft first degree?
Yes, ma'am.
No contest, guilty or not guilty?
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate you, time serve you. Pose court costs of $293, no victim contact with EC. Echo Charlie, okay? Thank you, ma'am. Good luck to you. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, except for paying the $293 in court costs.
Thank you.
You're welcome.
Judge,
Yes.
can we call a gentleman out of turn? His name is Abraham
No.
Bell for medical reasons?
No.
Not for medical reasons, okay.
Bell?
Yes. Come on up, Mr. Bell.
Where is he?
He's here at Main, Judge.
No. What page?
Page 10.
It's the first felony, first male felony.
Anybody else you want to call out of turn?
No, that's it for right now.
Okay, are you Abraham Bell, sir?
Yes, ma'am.
All right, sir. You have counts 22, 23, 24, and 25 are false owner info title items. False owner info pond items, $300 or more, $3,500 bond. Count 23 is dealing in stolen property, $3,500 bond. Count 24 and 25 is robbery by sudden snatching without a firearm or weapon. We need to talk about bond. Any objection to probable cause? These are add charges. Court finds probable cause.
Judge, Mr. Bell, I believe this is his third day in a row coming here. Magistrates, he's been ad charged. I believe he has over $30,000 bond. He has several no bond holds from out of county and a violation of probation. Considering that he's not going anywhere, Judge, I'm going to be asking for a $2,500 bond on counts 24 and 25, Judge.
Ask for 5,000.
State?
The state would ask for a $5,000 bond on count 24.
She said, tell her she said it. She said a $4,999 bond on a robbery yesterday.
And Your Honor set a $4,999 bond on this yesterday.
A robbery, same charge.
For the same charge.
Okay. No victim contact?
Yes, please.
Who's the initials, please?
One moment, Judge. I'm sorry, ask for it on 24 and 25.
Ask for
the 5,000 on 24.
The state would ask for 5,000 on 25 on count 25 as well.
And Your Honor, as far as the alleged victim,
Home Depot.
hold on a second. Just ask for no return to the target.
The state would ask for no return to the target on 11253 Pines Boulevard in Pembroke Pines.
And no return to
The Home Depot.
11253 what?
Pines Boulevard, Your Honor.
In Office Depot. As,
So it's Target and Office Depot, right?
yes, Judge.
All right, sir, so count 23 and 24 is 3,500 each, or actually, it's 34.99 each. Counts 24 and 25 are gonna be $4,999 each. There's no return, sir, to the target on 11253 Pines Boulevard and the Office Depot. Thank you, sir. Good luck to you, okay? Okay, next one, Barbara Patricia Garrett, please. And then we have James Michelle Hairstow.
No problem.
Okay, thank you. Ma'am, you have trespass, structure, or conveyance. You didn't show up at arraignment on March 7th.
March 7th?
Yes.
I can't recall
So
the
just do the
location
PC
or the date
for all.
of that ticket whatsoever.
Here it is, 1864.
Do you have the location of that ticket?
I'm gonna tell you in one moment.
Okay, thank you.
Regency Court Plaza at Young Circle, 1723 East Young Circle.
Did you hear that? What
That
day
must
was that?
It was January 2nd of this year, 12:45 p.m.
All right, so are we gonna resolve this case today, or what are we doing, folks?
Yes.
Judge, she did indicate she wanted to try to resolve it today.
State's offer to be time served, no return.
Okay, ma'am, do you wanna take an adjudication in time served and resolve your case today?
Yes, ma'am.
You understand I have to impose court costs of $293?
Yes, ma'am.
Okay,
How long will I have to pay that?
I can give you up to 90 days.
That'd be great.
Okay, no return to,
1723 East Young Circle in Hollywood.
did you hear that, ma'am?
Yes, I did.
Is that what you wanna do?
Yes.
Right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Is your name Barbara Patricia Garrett, Garratt? Put your hand down.
Yes, it is.
All right, it's my understanding you wish to waive your right to a trial, ma'am?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication, or ever been treated for a mental illness that would affect your
No, ma'am.
ability to understand what's going on here today?
No, ma'am.
All right, you want to plead guilty, no contest, or not guilty
No
to,
contest, ma'am.
let me finish, to trespass, structure, or conveyance?
No contest, ma'am.
Court's gonna accept your plea, find that's freely and voluntarily given. The court has reviewed the court file and finds probable cause for the plea. Court's gonna adjudicate your time served, you $293 in court costs, 90 days to pay, no return to 1723 East Young Circle, Hollywood. You understand, ma'am?
Yes, ma'am.
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Court is gonna accept plea, find that's freely and voluntarily entered after reviewing the court file. Thank you. James Michelle Hairston, please.
Judge, she's approaching, she's here at Maine.
Hello, ma'am, you're charged with trespass, occupied structure, or conveyance.
Yes.
She entered a front patio. She had an active trespass warning from March 3rd. State?
Your Honor, I don't have an offer at this time. It does appear she was arrested last year for trespassing at the same residence. This is her ex-husband's home. In that case, she was observed break.
They have a child, though, I think, right?
Well, I don't know what's going on there. I just know that there is a previous trespass warning. She was arrested for violating the trespass warning September of last year, where she was observed breaking into the back patio of the townhouse. She when he wouldn't open the front door, she went around to the rear and ripped open the screen to the back patio. So I'm not.
All right,
I have no
so
offer at this
court's
time.
gonna find probable cause. I'm not gonna resolve it today.
I wasn't gonna ask you, Judge. Judge, what I was gonna ask, there's more than meets the eye in this situation. The gentleman is the primary custodial parent, but there's no court order terminating Ms. Harrison's parental rights. They do have an arrangement, informal arrangement as far as visitation. She typically visits the child on Saturday, goes to the home. The gentleman has no problem. I know this was after Easter. It wasn't one of her scheduled dates. She just wanted to go and visit her child after Easter. When she advised me, cops were responded. No sort of incident. She left. I'd ask the judge, considering the circumstances, for a straight ROR. At this time, she is unemployed. She lives in Plantation with her parents. Her parents are elderly. She's right now applying for disability. So financially, her financial resources are zero. Her parents can't really help her. Judge, I'd ask you for an ROR or the alternative to have her released to pretrial, to have her supervised. So we believe
Standard pretrial release, thank you. ROR.
Thank you, Judge.
Amanda Nicole Harrick, please.
North Broward.
Good morning, Ms. Harrick. You have possession of drug paraphernalia.
Yes.
You have a no-show on your first court date with Judge Zeller, I believe. Possession of drug paraphernalia. Bond's been set at $5,000.
Correct.
Is this the drug court division?
Yes, Your
Or the
Honor.
regular division?
Well, if it's from Judge Zeller, it's drug court.
I just began. It was my first appearance with my
Yes.
attorney.
It's at a drug court.
All right, you're going before your division judge today, ma'am, at 1:45. Okay? Someone there at North Broward, a deputy?
Yes,
You know, Ms. Harrick has court today at the main courthouse before Judge Zeller at 1:45.
okay, I wasn't aware of that, but we'll make sure she gets there.
All right, ma'am, you'll go before Judge Zeller today. Good luck to you. Court's gonna keep the bond at 5,000. Speak to her about it, okay?
Okay,
Thank you. Michelle Lee Savio, please.
Yes, ma'am.
Okay, ma'am, you have a DUI, alcohol or drugs, first offense, $500 bond. Count 2 is DUI with damage to property or person of another, $1,000 bond. Counts 3 and 4 are basically RORs. There's no bond attached to it. It's resisting an officer without violence. And expired DL over 6 months. The court does find probable cause. Anybody want to be heard with regard to the $1,500 bond?
I didn't realize she was at North Broward. If I can have 1 second to speak to her.
Yes,
Okay, ma'am, go to your left.
thank you.
Speak with her. She indicated that she's been a resident here for 18 years, that she has no money in the bank. She works with her husband in the construction business.
Okay, so tell me what you're asking for.
Judge, she indicated she can't afford any bond at this point. She might be able to come up with the money. She hasn't been able to contact the husband. I'm asking if the court would consider RORing her to pretrial release standard. If the court is going to incline more to set a bond, we'd ask that the bond be left at $1,500.
All right, so I'll tell you what, can you call her husband? We'll recall the case.
I can try. Do you have his number, ma'am?
Yes, I do.
If you can ask the deputy to pick the phone up again and call me and let me have his number, and then I'll try to call the husband.
Yes, sir.
Thank you.
I know.
Zico?
Volume.
Yes, ma'am.
That was a long message. I thought you were talking to him.
I indicated that currently the bond is set at 1,500. She's indicated that if he may be able to pay that, he hopefully would be able to pay that. So I left that message that the bond currently is that.
All right, tell me something about your client. Does she have money in the bank?
She has no
Does she
money in
own
the
a
bank.
car?
She works construction with her husband, and she has no money in the bank. She's lived here for 18 years. I don't believe that she's a flight risk. What we would be asking for is for her to be ROR'd to pretrial release, just standard. If the court's not inclined to do that, then I would ask the court to leave the bond at 1,500.
It's fine.
Okay, standard pretrial release, ma'am.
Yes, ma'am.
No alcohol or intoxicants?
Yes, sir.
Ma'am, no alcohol or intoxicants, okay?
Okay, yes, ma'am.
Thank you. Good luck to you. Next
Thank
one is
you so
Rose
much.
Amelia Woods, please, and then we have Lysandra Lavette Johnson. Is there a medical reset again? Okay, Rose Amelia Woods, where is she? Main Jail, North Broward, Paul Ryan, Park County. Let's see.
All right, Your Honor.
All right, Rose Amelia Woods. Good morning, ma'am. You are charged with one count of burglary of a dwelling or structure or conveyance. Armed. Court does find probable cause. The court is going to order no victim contact, direct or indirect, with the alleged victim with the initials CPB. That means no contact in person, writing, texting, calling, or through third parties, and certainly nothing on social media. Do you understand?
Yes, ma'am.
All right, what are we setting bond at on, what are you requesting state on one?
Your Honor, and I'm not going to be requesting a no bond upon review of the probable cause affidavit, and I spoke with Deputy Derek Diaz.
Okay,
But I'm going to be requesting a $10,000 bond, pretrial release of the GPS monitor. I'm also going to be requesting, Your Honor, that the no contact order include any and all residents of this home. I do have concerns for their safety, considering the allegations also include that Ms. Woods struck one of the residents of the home after unlawfully entering, and that there were two small children present in the home.
all right, ma'am. Don't respond to the facts of the case, okay? Don't talk about them. It's not helping you. If you want to talk, I can allow you to speak to your attorney, Mr. Barbaric here, okay?
Yes, ma'am. I'm sorry.
All right, no, I understand. I just, you have the right to remain silent. Anything you say can and will be used against you, okay?
I'm sorry, ma'am. Yes, ma'am.
All right. Okay, so no victim contact, and all the residents, and includes all the residents of the home located at 143 Northeast 6th Court, Deerfield Beach, Florida. Okay, defense?
Judge, I can tell the court that she's been a resident here for 20 years. She is single with 3 children. They're aged 10, 9, and 6. She's currently not working, and she has no money in the bank. She lives with her mom here in Broward County. She indicated that her mom would be able and willing to help her bond out. I'm not sure of the amount that her mom would be able to post. I don't think it's a significant amount of bond. I would be asking the court to set bond, and especially in light of the fact, I don't know if the court's considering placing her on pretrial release with conditions, but if the court's inclined to just let her bond out, I would be asking for a $2,500 bond.
And Your Honor, just so the court's aware, the reason I'm asking for a GPS is that these two parties live very close to one another. If the court's inclined, matter of fact, and I just checked, if the court's inclined to order a GPS, I would be asking that it be a no contact within 100 feet to ensure that Ms. Woods can travel around her home and not violate the court's order. But being in such close
Okay, the court is gonna do a GPS, so, anything else from anybody?
nothing
Your Honor.
further.
All right, no victim contact and no contact with any of the residents of the home, ma'am. You see them, you walk the other way. You go to and from your house, you understand?
Yes, ma'am.
All right. No return to 143 Northeast Sixth Court, Deerfield. You're to maintain 100 feet. GPS level 2. Court's going to set the bond at $3,500. Thank you. Good luck to you, ma'am.
Thank you, Judge.
Okay, Lysandra Johnson, is she still a medical reset?
Yes, Judge.
Wonder how she's doing. Okay. Clinton George Tripp, please.
Mr. Tripp is present with us here at Main, Judge.
Okay, thank you. Okay, Mr. Tripp, you have a charge count, it looks like count 3, I can't really read, but it looks like petty theft, second degree, first offense. Court does find probable cause, it's an add charge. Sir, you're not to return to the public, you understand?
Yes, ma'am.
All right, and that's at 411 South Cypress Road.
Yes, ma'am.
Judge, as far as for clarification, the docket indicates this is 3. I know he's been in custody about like 7 days, I believe. What's 1 and 2? Anything else holding him, or what else?
He's got theft on count 1, a court order, no bond hold on a possession of PVP on count 2.
Okay, so court will keep his bond at $19, no return to the public, sir. Thank you.
Let me explain that to what just happened, because he was a little bit confused.
Okay. Next person is going to be Mark Angelo Bagno, and then Matthew Garnsey.
Yeah, I'll answer. Judge, just for clarification, Mr. Tripp, what he's indicating to me is he was out on a felony case. I believe it was PVP. I believe the state didn't file it in time, and he was ROR. He advised me that you were the judge that actually ROR'd him. He came back subsequently on a petty theft, and I believe some judge, I don't know if it was Your Honor, revoked his release on that case and held him no bond. He's wanting me to ask you to see if you could go ahead and reinstate his bond. I was trying to explain to him procedurally, I mean, he would have to go back in front of his assigned judge, but he wants me to ask you to see if you could do anything for him.
I would like to resolve everything. I would like to resolve the
You know
petty
what,
theft.
Mr. Romero, look it up, and you can put them on this afternoon's docket if you want, okay?
But, Your Honor, we would object to that. Another judge ordered him to be held no
All right,
bond.
let him look it up. If he wants to put it on, then you can argue that then. $19 bond, no return to Publix. Look it up and bring it later, okay? Do it this
But it's
afternoon.
another judge, Judge. It was another judge. That's why I advised
I
him.
know, but tell me
Procedurally, I
about
don't
it,
think
but I'm saying we can deal with it later on this afternoon.
I'm
We have less
dealing with it
cases.
now.
I know, but I don't want to deal with it now. I'm just dealing with the count 3. You're asking me to address other bonds and, start looking in the computer. I'll look at it at 1 o'clock if you want, or 1:30, whatever time you want, okay?
Yes, Judge.
Thank you. Mark Angelo Papagano, please. Papagno. Hey, are you Mr. Papagno? Yes, no?
Richard Pagano is here present, Judge.
All right, sir, you are charged with 1 count, touch or strike battery. $1,000 bond, court does find probable cause. No victim contact, direct or indirect, with the alleged victim with the initials DEM. Do you understand, sir? No contact in person, calling, texting, writing, social media, or through third parties, okay?
Yes, Your Honor.
All right, let's talk. One of you heard of with regards to the $1,000 bond? Can you afford it?
Judge. No, he can't. He's only asking at this time, his only request is a straight ROR. If Your Honor's not inclined to do a straight ROR, then the defense would ask you just to leave the standard bond in place. per Mr. Pagnot's instructions. What kind of time?
We would be opposing an ROR, we would be opposing pretrial. He's been arrested 4 previous times for failing to appear in court. He has 8 prior felony convictions, 7 prior misdemeanor convictions, $2,000.
$1,000 bond, thank you. Next one's Matthew Garnsney. Hey, Mr. Garnsney, how are you today, sir? You're charged with 1 count, touch or strike battery. Good morning. The court does find probable cause. The court's going to order no victim contact, direct or indirect, sir, with the alleged victim with the initials MMLH, okay?
Yes, ma'am.
That means no calling, texting in person, contact through third parties, social media, or writing. Do you understand?
Yes, I understand, ma'am. Can I give my side of the story? Would that be okay?
No,
Real quick?
today is not the day to do that, sir. Today's only probable cause, which means on the
Okay.
face of it, does it appear that you committed this crime? That's all today is, but you will have your day in court, okay?
Okay, I just want to apologize, that's all,
All right.
yeah.
All right. State,
Your Honor,
$1,000 bond.
I'd be asking that to be kept in place. In 2004, Mr. Garnsney was convicted of 2 counts of aggravated battery with a deadly weapon. He was sentenced to 10 years in Florida State Prison and was released in 2014.
Ma'am, I stay out of trouble.
Judge, I was just on the phone. Mr. Garnsney gave me a phone number to call for Charles. I was able to contact Charles. Charles indicated that he's going to contact your father and that his father would be able to post a $1,000 bond.
Okay, $1,000 bond, sir. Good luck to you. Your dad's gonna post it. You too. You too. J. D.
Joseph,
Oswald.
is your present, Judge, I
Joseph.
think?
I was waiting for you to say the whole name. All right, I can't see you at the main jail. Craig's there, maybe he'll reset it.
I have him.
Okay.
There you go.
All right, sir, you have 3 capious traffic. Keep failing to appear. You have a no-show. Driving while license is suspended. November 8th, no-show. Driving while license is suspended. June 28th, these are all 2017. And then you have another no-show, which was 3 months before that, on March 22nd, 17, for driving while license is suspended. Bond's been set at $1,500.
Judge, Mr. Joseph asking me to ask Your Honor if you would consider resolving this case today for time served.
On all 3 cases?
I don't have an offer that would result in a 5-year habitualization.
I did advise him as far as the consequences. He said he understood and he still wishes to ask Your Honor if you would consider resolving this case for
Does
time
anybody
served.
know why his license is suspended to begin with?
Let's see. Failure to pay and failure to appears. Failures to appear. That's, no. I give Patrice, I give her crap, so I gotta hold myself the same. No. Did you say something? Did you say something over the radio?
Okay, this is what I can do, Mr. Romero.
Yes, sir.
He can have the option, I can put him on a GPS to ensure him coming to court. I know it's
Yes.
driving while license is suspended, however, he's done it 3 times, or he can resolve all his cases today. If he wants to go get his driver's license, he might be able to get into a payment plan or something like that and resolve his driver's license. I don't want him admitting just to get out of jail, but one way or the other, he can either admit to the 3 charges, be habitualized, or he can go with the GPS monitor and try to get his driver's license. If he doesn't
Yes, Judge,
show
thank
up and
you.
he gets violated, then he's just gonna be back here again with the 3 charges.
Yes, sir.
she wants to do an open plea.
Ready?
So I'm making a note. This is an open plea.
Mr. Joseph, he appreciates, the two offers, Judge, and he wishes to accept as far as, the monitor, level 2, pretrial, Judge. With the monitor. You just, oh, Judge, sorry. He doesn't want the monitor. I apologize. I got confused.
All right, so tell me what you want, sir. You want to take the plea or you want the monitor?
Actually, he wants a plea, Judge. He wants a plea.
All right. Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right. State your first and middle and last name.
J. Oswald Joseph.
Okay, and that's J-A-Y,
Yeah.
Oswald, O-S-L-W-A-L-D, Sylvan Joseph, J-O-S-E-P-H.
Yes.
All right. It's my understanding you wish to waive your right to a trial, sir?
Yes.
Anybody forcing you to do this?
No.
You understand that we're trying to resolve 3 cases here today? Driving while license is suspended? Yes?
Yes. Yes.
You had enough of time to talk to your attorney, Mr. Romero?
Yes.
You understand that if you get 3 convictions within 5 years, the Driver's License Bureau is going to revoke your license for 5 years as a habitual traffic offender, and this is going to make you a habitual traffic offender. You understand that?
Yeah.
And you understand that when you drive again and you get caught, you're facing up to, well, actually, it could be charged as a felony, correct, State?
Yes, ma'am.
Could be charged as a felony, sir.
Yeah.
Ever been treated for a mental illness?
Nope.
Are you on any medications at this time?
Nope.
Under the influence of any drugs or alcohol?
Nope.
You're doing this on your own free will?
Yep.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings, sir, and affect your ability to remain in the United States?
Yeah.
Okay, understanding what I just explained to you, are you pleading guilty, not guilty, or no contest to driving while license is suspended in case number 17-4065? Let me start again. 17-40645 TC40A, 17-19334 TC40A, and 17-5406 TC40A. Driving while license is suspended in each case. How do you wish to plead?
No contest.
Okay, the court is going to accept your plea. Find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court is going to adjudicate you on counts 1, 2, and 3. Time serve you on each count. Impose court costs of $293 on counts 1, 2, and 3. $293, so that's times 3. And the court will give you 6 months to pay that, sir, okay? You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. You're done with your cases, except for paying your court costs, okay?
Okay.
Thank you. Clifton Paris, please.
Mr. Parrish, come on up, please.
May be resolved. Sir, you have 2 capias. You have an unserved summons for a petty theft, and he has another capias for a petty theft. Bond is set at $100 and then $500. This is in Division MS. Okay.
Mr. Parrish wishes to resolve his cases today.
He also has 2 different addresses, just to let him know. So, State.
One moment, Your Honor. It rang and then hung up. Okay.
Next one after Mr. Parrish is going to be Fionn P. Fitzpatrick, Timothy Kylo, Milton Scott, and then Raymond Arnold.
Okay. Your Honor, the state's offer on, well, I'll start with count 2 would be adjudication. Hey, hold on 1 second. Adjudication time served, no return to Walmart on 3001 North State Road 7 in Lauderdale Lakes. On count 1,
You said Walmart?
yes.
Sorry, I started writing down here.
Sorry about that.
Okay.
I'm sorry. And on count 1, it'd be adjudication time served, no return to the Walmart located at 2500 West Broward Boulevard in Fort Lauderdale.
2500?
West Broward Boulevard. Hey, how's it going?
Hey, did you hear that?
Yes, ma'am.
Is that what you want to do, sir?
Yes.
You understand that you can't return to these two Walmarts?
I'm not gonna return to the 2 Walmart.
Okay. Raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, ma'am.
Is your name Clifton Parrish, Parrish?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial in both these cases, sir?
Yes, ma'am.
Put your hand down. Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
You understand that if you get one more petty theft, or, well, if you get one more petty theft, sir, it can be charged as a felony. Do you understand that?
Yes.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Are you on any medications?
No, ma'am.
Have you ever been treated for a mental illness?
Yes, ma'am.
Does your mental illness, don't tell me what it is, affect your ability to understand what's going on here today, sir?
Sometimes.
Okay, what about today, sir?
Well, I understand today.
You do understand today, and you're not on any medication, right?
That's right.
Okay, you understand that if you're not a U.S. citizen, plea of this charge could result in deportation proceedings, sir, and affect your ability to remain in the United States?
Yes.
Have you had enough of time to talk to your attorney, Mr. Romero?
Yes.
Understanding what I just explained to you, are you pleading guilty, not guilty, or no contest to petty theft in case number, let me finish, 171892 MM10A and 1784 MM30A? How do you plead, sir, to those two cases?
No contest.
Okay, the court is going to accept your plea. Find that's freely and voluntarily entered. The court has reviewed the court file. Finds probable cause for the plea. The court's going to adjudicate you, time serve you on each case. Count 1, no return to the Walmart at 2500 West Broward Boulevard, Fort Lauderdale. And then count 2, no return to the Walmart, 3001 North State Road 7 in Lauderdale Lakes. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Oh, I forgot. Court costs in each case on count 1 and 2 of $293. Thank you, sir. Good luck to you.
Just doing this stuff, take this time to look up
Fiona
stuff.
Fitzpatrick, please.
That's a medical reset.
Then we have Timothy Kylo, please, and after him is Milton Scott.
Medical reset. Mr. Scott, come on up. You're next.
And after Mr. Scott, we have
He's
Raymond
approaching.
Peter Arnold. Okay, Milton Scott, please. Is that your
Yes,
name?
ma'am.
Good morning, sir. You have trespasser entry on property. Court does find probable cause. The court's going to order no victim contact, direct or indirect, with the alleged victim with the initials MH. That means no going to their home, no calling, texting, writing, nothing on social media, and no contact through third parties with MH. Do you understand, sir?
Do you understand? Yes, sir.
Wait a second, it's not MH.
Yes, it is.
Well, I have a victim notification that has a Clinton Williams.
That's a designated contact, Your Honor.
I see. All right, anybody wish to be heard? $25 bond, trespass, entry of property unlawfully. He was taking
Judge, I
a
don't know
shower.
if this state-
No, I don't have an offer.
No. Judge, in speaking with Mr. Scott,
There's a
he
vacant home.
cannot afford the $25 bond. He's 54 years old. At this time, he is homeless. He's financially indigent. There's no one that he's advised me that he could contact to help post his bond.
All right, so does he want to plea open to the court, or does he want to?
He wants to try and resolve if Your Honor would consider a time served.
Okay, State, you don't want to agree to that?
No, I don't know. I wouldn't. No, I'm not making an offer, but to advise the court, if the court is going to make an offer and an open plea, he has 13 prior felony convictions, 21 prior misdemeanor convictions, a total of 39 unknown dispositions. He has, and I believe it's relevant considering the allegations, a woman has a non-expiring injunction against him out of.
Okay, I'll give him 7 days Broward County Jail credit for time served.
Let me count on. He wishes to accept the court's offer, Judge.
Yeah.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth? Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Milton Scott?
Yes, ma'am.
All right, put your hand down. It's SCOTT.
Yes, ma'am.
All right, it's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication that would affect your ability to understand what's going on here today, sir?
No, ma'am.
All right, you don't have any pending felony cases, do you?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to discharge can result in deportation proceedings, sir?
I understand.
Okay, you agree not to go back to this residence where you were taking a shower?
Yes, ma'am.
Hey, you can't go into homes even though no one lives there. You understand that?
All right.
All right, you want to plead no contest, trespassing, entry on property
What's that?
unlawfully?
Yes, ma'am.
Okay,
I
the
don't
court's going to
ever
accept
look
your
on
plea,
CCI.
find that it's freely and voluntarily entered. Court's going to
It's a
give you
different
7
system,
days,
jazz.
Broward County Jail,
It has everything.
with credit for time served, no victim
here,
contact, and
Wisconsin.
no return to the residence.
You can't use it, you're not
$293 in court costs. You have
Keep it
30 days to appeal the sentence to the
This
court.
has-
If you can't afford an attorney, one will be appointed. Good luck,
It
sir.
would be illegal if it used to.
Raymond Peter Arnold,
give you
please,
access
and
to
then
money, people
Matthew
would be charged with it.
Poe Leon.
Mr. Arnold is a municipal ordinance case.
Okay, who is that with?
See, like it has access to CCI.
Is anybody that's Hollywood? All right, Mr. Arnold, you have a no-show for an arraignment.
Every 2 years.
Can you find out this
Has
property?
3-up or certification. This is through the FBI.
Do you have the case number? Here you go. Okay, sir, you have trespassed private property. You failed to show for arraignment. Want to try to resolve your case today, sir?
Yes.
You agree not to go back to this property?
Yes.
M.O. Five three zero one.
It's trafficking heroin. He faces. Hold on a second. It's a first degree felony. He faces. Let's see. Heroin,
1723.
I think it's 7 years, but let me make sure.
Okay, sir, you agree not to return to 1723 East Young Circle, Hollywood, Florida?
Yeah.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
15 years. Mandatory
Okay, your
prison
name is
sentence.
Raymond Peter Arnold, A-R-N-O-L-D.
Yes.
Anybody forcing you to do this?
No.
Want to waive your right to an attorney and trial, sir, in this case?
Yes.
Ever been treated for a mental illness or on any medications?
I'm supposed to be on medication, but can't afford it.
Comes to the
Okay, are you
trafficking,
under the influence of
drugs,
any drugs or alcohol?
he's got, let's see, 2
You understand
prior
what's going on here
felonies.
today?
Grant that.
Yeah.
You understand that
So
if you're
he's
not a
gonna
U.S.
score some
citizen, a
points.
plea of discharge could result in deportation proceedings?
Yes.
Okay, and you agree not to go back to 1723 East Young Circle, Hollywood, Florida?
Well, that's a no.
All right, how do you want to plead to trespass private property or after notice? Guilty, not guilty, no contest.
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea, no return, adjudication, and time served, $78 in court costs. Thank you, sir. You have 30 days to appeal the sentence of the court. Can't afford an attorney, one will be appointed. You're done with this case. Thank you.
75
Matthew
grams of cocaine.
Polion.
Mr. Polion is here present.
Polion, I'm sorry, and then
This
Kevin
guy's a
Gary Hurt.
drug dealer. I mean,
Okay, Mr. Polion, you are charged with possession of cannabis, 20 grams or less, possession of drug paraphernalia, the possession of cannabis, $100 bond. And then he has a capious misdemeanor for at a Deerfield Beach, failure to obey a police officer. It's an M2. Court finds probable cause. What are we doing with these cases, folks?
Judge, and speaking Mr. Polion, he wishes to ask the court if you would consider resolving the case. We'd be asking for a withhold on counts 1 and 2 and a time served on count 3, Judge.
I have no objection.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, you're Matthew Polion, P-O-L-E-O-N.
No, I just don't want them.
It's my understanding you wish to waive your right to a trial?
You wish to waive your right to a trial?
Yeah.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication, sir?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes, ma'am.
Understanding what I just explained to you, are you pleading guilty, not guilty, or no contest? Possession of cannabis less than 20 grams, possession of drug paraphernalia, possess and/or used, and failure to, just get the proper name, failure to obey a police officer, no contest?
No contest.
Okay, the court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court is going to withhold on counts 1 and 2. Count 3, the court's going to adjudicate and time served, and that's the failure to obey the police officer. The court is going to impose $293 in court costs on count, I'm sorry, $293 on count 3, the capious, and $308 in court costs on count 1, the possession of marijuana under 20 grams. Court will take judicial notice in count 1 and 2 of the Broward County jail time. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir. Okay? Kevin Gary Pert, and then Vincent Leo Scanlon.
Mr. Pert is approaching, Judge.
Okay, Mr. Pert, you're charged with 1 count of petty theft, first degree, between $100 and $300. Court does find probable cause. Court's going to order no return to Walmart at 555 West Atlantic Boulevard in Pompano Beach. Do you understand, sir?
Yes, ma'am.
What are we doing with this $100 bond?
Judge, I'm going to be asking for an ROR. Unfortunately, right now he's unemployed. He's looking for work. Unfortunately, he was separated from his wife last year. He lost his job last year, and now he's homeless. He's looking for work, but he has no sort of financial access to funds to post a monetary fund. Judge, he's 55 years old. I'm sorry, he's 33 years old, been here for about 12 years in South Florida. So, Judge, I'd ask you to consider an ROR on his behalf.
He was arrested a couple weeks ago and bonded out $25 on a trespass when he was trespassing at the Seminole Hollywood Classic Casino.
Judge, my understanding also is right now he has no prior convictions or anything like that. He has no prior record besides that one case that Mr. Lender just
At
mentioned.
least he's not at the casino. Not lessening it, I'm just saying.
I mean,
All right, this is what the
gambling's legal. I mean,
I
I'd rather him
understand.
gambling than stealing.
ROR, standard, pretrial release. He just has to show up the one time.
Yes,
And
Judge.
call in 2 times a week.
Yes, Judge.
But he doesn't have to go once a month, okay?
Yes, Judge.
Let me confirm his address. It says at large.
Correct, he's home.
How's he gonna get notice? Pretrial will give it to him, I guess? Okay. Sir, do you have anybody's address where you could get notice that it could get mailed to?
I know my mom, but I don't know her address. I don't know it out of my head.
All right, well, when you do know it, why don't you write your public defender or have your public defender come with it to court and let them update your address. At least you'll get notice at your mom's, okay?
Okay.
All right, thank you, sir. Tell him, Mr. Romero, he has to report within 24 hours.
Yes, Judge. They kindly gave him a map already, and I'll let him know right now.
Okay. Vincent Leo Scanlon, and then Isaiah Brian Barfield.
Mr. Scanlon is here present, Judge?
Okay, Mr. Scanlon, trespass property, not a structure or conveyance. Court finds probable cause, no return to the Sunoco gas station. This was in 3900 North Federal Highway. This in Lighthouse Point? Yes, it is. 3900 North Federal Highway, Lighthouse Point. You understand, sir? You cannot return there.
Yes, Your Honor.
Judge, Mr. Scanlon is asking if Your Honor would consider resolving his case time served.
State, do you have any priors on him going back there again?
His last arrest was in Broward was November of last year, and that was just down the road a little bit on North Federal. Yeah, there was another one that was also in the area. I don't have any prior arrests in Broward at this specific location. It's just the prior arrest in the same area.
All right, sir, you can't solicit for money. You understand?
Yes.
All right,
Yes, Your Honor.
want to resolve it?
Yes.
This is what I'll do. He's done this before. I'll adjudicate time served, 3 days Broward County Jail, credit for time served, if he wants.
You reconsider it wasn't at the same location, so he's been as far as keeping his word, not returning to the same location. So would you consider time served, Judge?
Sir, are you not going to go back there again?
No, ma'am, I won't go back.
All right, I don't want to see you back here again. Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, Your Honor.
Okay, is your name Vincent Leo Scanlon, Scanlon?
Yes.
Okay, it's my understanding you wish to waive your right to a trial, sir?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication that would affect your ability to understand what's going on here today?
No, Your Honor.
Ever been treated for a mental illness?
No, Your Honor.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes.
Okay, you understand that I have to impose $293 in court costs?
Do I possibly work that out in the service?
I'm not going to do that today, sir, but you can send a letter to the court and ask them to do that, okay?
Yes, Your Honor.
All right, so want to plead no contest to trespass property, not structure or conveyance?
Yes, Your Honor.
You understand that if you come back here again, you could be facing more jail time. You understand that?
Yes, Your Honor.
All right, court's going to accept your plea, find that's freely and voluntarily entered. The court's reviewed the court file, finds probable cause for the no contest plea, correct?
Yes.
All right, adjudicate time served, $293 in court costs, no return to Sunoco, 3900 North Federal Highway, Lighthouse Point, Florida. Thank you, sir.
Good luck, sir.
Isaiah Brian Barfield, please.
North Broward.
Here's your Coconut Creek Casino. Eric.
Yeah.
All right, sir, you're trespassing occupied structure or conveyance at the Coconut Creek Casino. Bond set at $100, court finds probable cause. Court's gonna order no return to the Coconut Creek Casino. You understand, sir?
Yes.
You were given prior notice against entering or remaining. You seem to keep going back there. So you were given a notice, don't respond, on 9/22/2017. What are we doing with this?
Judge, I had an opportunity to speak to him. He wanted to ask the court if the court would consider RORing him on this case. I can tell the court that he's lived here all of his life. He has no money in the bank. He has relatives that live here in the area, cousins and uncles. And he indicated that he does try to work when he can. He just basically does odd jobs, but it's not enough. He has nothing in savings at this point to afford any kind of bond.
He's out on $100 bond for from last month for trespassing at the Seminole Hard Rock.
And he's back there again.
He's at a different Seminole casino, but yes.
All right, sir, I'm gonna change this. No Seminole casinos. You can't go to any of them, you understand?
Yes.
All right. ROR, standard pretrial release, you come back here again? Pretrial's probably gonna get revoked, thank you. Matthew Jeffer Rosengarten, please.
Okay, wait, guys, yours are gonna be coming up soon because we just got to the felonies.
Mr. Rosengarten, Matthew Jeff.
Judge, he's approaching, just to apprise the court, he defined the services of public defender. I would just ask, as a friend of the court, Judge, if you could just advise Mr. Rosengarten not to talk about the facts of the case,
Sure.
considering the serious nature of the offenses.
Sure.
And at that time, then,
Of course.
see what happens.
Okay.
Not guilty, Your Honor.
Okay, are you Matthew Jeffrey Rosengarten, sir?
Yes, ma'am.
All right, sir, you have the right to remain silent. Anything you say can and will be used against you. You have some very serious charges, sir. You also have the right to have an attorney appointed if you can't afford one. And today, it's my understanding that you refuse the services of the public defender, sir. Is that correct?
Absolutely. Absolutely. He's worthless.
Okay. Do you have an attorney of your own choosing, sir? Did you hire one for today?
I plead not guilty, and my attorney will be present at the next hearing.
Who's your attorney, sir?
All services that you require with my credit card that you have in your possession.
Okay, sir.
Requires a bail.
Sir,
and I
don't
will
talk
pay
about the
bail.
facts of your case or anything else. Who is your
No, I
private
have
attorney?
no intention of doing such.
Who is your private attorney, sir?
Anthony J. Scremin.
Does anybody know who he is? Spell the last name.
SCREMIN 305-576-8880.
And it's Scrimmage? Well, I'm gonna call him right now, okay? Hold on,
They
sir.
refuse medical attention to me because I have a condition called PTSD as well as other things that are causing me severe problems. They refuse me and deny me my basic fundamental rights. I'm going to be suing Broward County and Palm Beach County explicitly with prejudice.
Okay, you said 576?
8880.
Put him on speaker. Yes, hi, this is Judge Malika calling from Open Court, Broward County Magistrate Court. How are you?
I'm fine, thank you.
I want to know, is there an attorney scrimmage there, please?
No, I'm sorry, he's not actually. He is in the Metro Justice Building on another case.
All right, we have somebody here that's charged with attempted felony murder and other charges. Their name is Matthew Jeffrey Rosengarten. Do you know if Mr. Scrimmage represents him, or, because it's my understanding Mr. Rosengarten tried to get a hold of him, but wasn't
I
allowed.
never called in for for this reason.
Sir, you don't need to yell.
You're in
Relax.
contempt of my court now.
Sir, just
You're
relax.
lying.
Okay.
You're lying.
Ma'am?
Yes.
All right. Are you familiar with Mr. Rosengarten?
I know who he is. Yes, ma'am.
All right. Do you know if Mr. Scrimmage, excuse me, hold on. Hold on, I grabbed the phone by accident.
No problem.
Mr. Scramage is going to be representing him?
I do not know that. I have not spoken with Mr. Scremen. I will try to get a hold of him. Is there a number that I can have him return the call?
What I'll do is I'll have my judicial assistant call back in a couple moments. What's your name?
Okay, my name is Ida.
All right, Ida, do you think you could get a hold of him by cell?
I am going to try. I'm sorry. What is the judge's name?
Malika, that's my name. Mollica. My first name is Kim.
Monica Kim. Thank you. Okay, I will try to get a hold of him.
All right, we'll call you back in just a little bit, okay?
Thank you for your call.
Thank you. All right, have a seat, sir.
Thank you, sir. Ma'am.
Alexander David Livingston.
Mr. Livingston, come on up, please. Be careful.
So what bonds were you thinking?
Hello, Mr. Livingston.
For each
All right,
count.
sir, you have battery on an officer or firefighter.
That's
Counts 1 and 2. Count 3 is resisting an officer without violence, $100 bond. Count 4 is motorcycle without eye protection. It's actually not for magistrate court. That's a civil traffic infraction. And then you have count 5, driving while license is suspended, second offense, $100 bond. The court's going to order no victim contact, direct or indirect, with the alleged victims in this case, with the initials WB and LG. That means no contact in person, calling, texting, writing, through social media, liking, disliking, or anything like that. Do you understand?
Yes, I do.
Okay, and that also includes no contact through third parties. State, let's talk about a bond on 1 and 2.
The state would ask for $3,000 on each count. The defendant has an open DV battery case, a tampering with witness or victim, as well as open trespass and open DUI, and a prior 2017 adjudication for resisting arrest without violence, as well as a withhold of adjudication for 2017 LSA, and it's all out of Palm Beach.
Okay, he was operating a moped is what happened. All right, defense?
Judge, it's being Mr. Livingston. He's been residing in South Florida his entire life. He's 20 years old. At this time, he is employed. He works for a company called Marina One. He works on boats. He's been there for about 1 year. His wages makes about $10 per hour. He's also going to school. It's an online school. He's trying to obtain his GED to try and better himself. At this time, he lives with his grandparents in Palm Beach.
Is that 311 Southwest 2nd Street?
Correct. That is correct, Judge.
Okay.
From what he informed me, they're retired, and that's who he's going to be counting on to help post his monetary bond. We'd be asking you, just said, on these third-degree felonies, $1,500 on count 1, $1,500 on count 2. We believe a $3,000 total bond on counts 1 and 2 would be reasonable at this time, Judge. And we'd also ask you to sign an order allowing us to photograph Mr. Livingston's injuries that he sustained from this incident, Judge.
Okay, the court will grant your photo order. Court's going to do $2,500 on 1, $1,000 on 2. Count 3 and 5 will be $100 each, okay? Thank you.
Yes, Judge.
No victim contact, sir. Sir, did you hear me? No victim contact, okay? Good luck to you. Jeffrey Stewart
No, it's
Jacobs,
not that
please.
big of a- okay.
25. Is
Mr.
that what I
Jacobs,
put? 25 and 1,000, correct?
Okay.
Thank you. I'm sorry. What did you say, Mr. Romero?
He's on bond for 6 charges.
No, this is Mr. Jacobs.
Hello, Mr. Jacobs. How are you?
Pretty good.
All right, sir. You have a grand theft between $300 and $5,000, $1,000 bond. Count 2 and 3 is fraudulent use or possess ID of another person without consent, $1,000 bond each count. so that's a total of $3,000. And counts 4 and 5 have a $1,000 bond. Possession of hydromorphine, which is Dilaudid, and unlawful possess or personal ID of another, 5 or more, $1,000 bond. The court is going to order no victim contact, direct or indirect, with the alleged victim with the initials JJ. That means, and you heard me tell other people, no contact in person, calling, texting, writing, and social media or third parties. You understand, sir? Okay, court does find probable cause, by the way. $5,000 total in bond. Anybody want to be heard?
Yes, Judge. The state would ask for, on each count, for $2,500 bond. And the reason being is that he is on bond for 6 different charges. Felony credit card fraud and 1 count of grand theft.
Is that 1 case or 6 cases?
It's 6 cases total. 1 case and 7 charges.
Okay. All right, defense?
And he was out on bond when this occurred.
Okay. Defense?
Judge, at this time, since the state did mention his parents were the actual persons, I believe, that posted his bond. All their
I see that.
All their funds have been exhausted. From what he informs me, he lives with his parents. We'd be asking you...
Is that James Jacobs?
Yes, ma'am.
That's who it is. And I just ordered no victim contact.
Oh, that's the alleged victim on this incident?
That may explain why their resources are exhausted.
One moment, Judge.
They were what?
The bonds were surrendered.
They were? The bonds were surrendered.
Oh, let him know. Judge, he's 36 years old, been residing here his whole entire life. He's working at Dairy Queen. He just started that employment. He's a cook, making $8.75. Really, there's nobody that can post his monetary bond now from what he understands. Your Honor did order no contact. I did advise him he can't go back where the alleged victims reside, so he's going to have to find another place to live. He says he has a friend who resides at Davie, and that's where he'll be staying at. What we'd be asking you to do at this time, considering that he's out on a case, the no victim contact, all these things this court is taking into account, I'd ask you to consider releasing him on pretrial level 2, Judge.
Okay, court's gonna leave all his bonds in place, GPS level 2. No victim contact. Christopher Quigg, Quigg, and then Alan Antoine Roundtree. Okay, are you Mr. Quigg, sir? Sir, you're charged with 1 count of possession of heroin, $1,000 bond. Counts 2 and 3 are basically an ROR, there's no bond attached. Drug paraphernalia and driving with a suspended or revoked license. Court finds probable cause. Anybody want to be heard with regard to bond?
Yes, Judge. We're going to be asking you to release Mr. Quigg on pretrial release. He did advise me that he has priors, but I believe it was back from 2015. What we have before you is a nonviolent offense. He's 37 years old. He's working part-time at a company where he installs security cameras. He lives in Cooper City with his father-in-law. He pays about $60 a week to stay there. He's so welcome there, so he'd be able to be receiving notices and everything like that. So we'd be asking him for standard pretrial release.
Like the TL record and stuff.
State?
The state has no objection to pretrial release with drug testing.
Okay, standard pretrial release.
Thank you, Judge. And he'll have to report within 24 hours.
Testing, random drug testing.
Yes, Judge.
That means no drugs, sir, or intoxicants unless they're prescribed. You understand?
Yes, ma'am.
Let me just hold on. Don't leave yet. Is your address 5101 or 2831?
5101.
Okay, thank you. If your address changes, Notify the clerk of the court with your case number immediately in writing, and also your attorneys, okay?
Yes, ma'am.
Thank you. Alan Roundtree, please, and then Joshua Jones. Okay, are you Mr. Roundtree? Are you Mr. Roundtree? Are you gonna call the
Yes.
that? Okay, sir, you're charged with driving while license is suspended. First offense, $100 bond. Count 2 is false ID given to a law enforcement officer. It's basically an ROR. You do have a no bond hold on your violation of probation. You are going before your division judge. What is it, MP?
Judge,
No,
my
that's
understanding is
felony.
he's on felony probation in Dade County.
Oh, that is
What's
Dade?
the
All right, so he has a no bond hold, but hold on.
Right.
You have a KPS traffic $250 bond. And then I have an no, that isn't, wait. And then I have an out-of-county hold for a felony. The probation, I have MP, which is Judge Jill Levy, for April 9th, which is this coming Monday at 1:30 p.m. The probation violation, can anybody tell me when he's going to court on that? Is that for Broward?
No, it's in Dade County, Judge.
There's an out-of-county hold for a felony too.
Right, that's what it is. That's the probation hold.
Count 3's under 94806.
I see,
Count 5's
Dave.
under the warrant.
Okay, I got it. Took me a while, but I got there. Okay. So 3 and 5 are Dade, correct?
Yes, ma'am.
Thought it was only 5. All right, so court does find probable cause. What were you saying with regard to the bond?
Judge, since he has to deal with this felony probation case in Dade, I'd actually consider an ROR in the Broward, cases, so that Dade County can come and pick him up.
Well, I mean, on count 4, he's already got a date to see his judge in Broward.
All right, I'm gonna set the bond on count 1, $99, and count 4, $249. Gonna see Judge Levy on Monday. Thank you. Okay, ma'am?
Yes.
Do you know if there's any way, we gotta get this gentleman to make a phone call to him to see if he can be retained.
Okay.
Do you know
all
when
I
he's
can give
available?
you- He is not in the office, no.
Do you know when he will be in the office?
I'm expecting, I'm gonna say around 1:30 is when I'm expecting him in the office. I can give you a cell number if he wants to call.
All right, why don't you, hold on, I'll take you off the record. Go ahead. What's his cell?
What does FX mean?
Your mic's on, by the way. Okay, 9847? Okay. And can you spell his first and last name? Okay, that I asked.
So it's gonna be probably just being, it's gonna be held until.
All right, is there any way he can appear by phone? We can contact him? All right, maybe you can contact him and tell him I'm going to try him on his cell phone just to discuss a couple things further with Mr. Rosengarten to try to see if there's maybe a time they could connect on the phone. Mr. Rosengarten can speak to him, so.
Would you increase, like,
Hold on one moment. Okay, let's just briefly recall Mr. Rosengarten.
They're going to get him right now, Judge.
All right. His attorney said he needs to talk, he says he hasn't been formally retained, but he hasn't heard from him. So somehow we gotta get him to get in touch with this attorney. I do have the attorney's cell phone number. Where'd the number go? Okay, while we're waiting for him, is he far?
He's here.
Okay.
He's coming up, Judge.
Okay, Mr. Rosengarten, we are going to, I called your attorney's office and spoke to his assistant, Anthony Scrimmon's assistant. He said that he hasn't spoken to you, and I said, I'm aware of that. So we're gonna call in a little bit, try to get him on his cell phone. Supposedly, he's not gonna be back in the office till 1:30. So we might have to reset you.
After I plead not guilty and post bond and I'm free to go, is that correct?
Say that again?
He's gonna represent me post this hearing.
He didn't say, he hasn't even spoken to you.
Not guilty.
All right.
I'm representing myself as my attorney here. He will be my attorney in the next court hearing.
Okay, so you wanna represent yourself at this hearing, sir?
At this hearing, yes, ma'am.
Okay, you do? I could call him. On the
He
786?
expressed interest in my case.
Hold on. The public defender is on the phone with him, sir. So what is he saying? Is he gonna represent him? He wants to represent himself.
At the hearing.
Yep.
I saw the information. I told you they're worthless asshole. We're not on the magistrate yet.
You have reached a number that has been disconnected.
You're on.
Hold on one moment. Okay, Mr. Rosengarten, we can hear everything you're saying, okay, sir?
Okay. Yes,
All
ma'am.
right,
I hate to
Mr.
be
Scrimmen.
disrespectful, but I hate to be disrespectful.
Okay. Okay, Mr. Scrimmen, my name is Judge Kim Malika. I'm in Magistrate Court in Broward County. We have a gentleman here by the name of Matthew Jeffrey Rosengarten, who states that he wasn't allowed to make a phone call. He has some serious charges. He does not want the public defender to represent him just for this hearing, for purposes of his hearing. He wants to represent himself. It is an attempted felony murder charge. It's an aggravated assault with a deadly weapon without intent to kill, which bond needs to be discussed and set. We need to talk about probable cause. There's also a criminal mischief, $200 or less, first offense, $25 bond. Count 4 is carrying concealed firearm, $1,000 bond, and count 5 is discharge a firearm in public. I know that you have not had the opportunity to speak to him. I can reset this for this afternoon.
No, I want to take care of it today.
Your client or your potential client wants to take care of it today. So I can reset it for this afternoon, giving you an opportunity.
No, I want to take care of
Hold
it now.
on, sir.
You're asking him nothing. You're asking me everything.
Okay, sir.
I represent myself at this hearing, Your Honor, not him. He's going to follow up with the next case.
Okay, do you hear that, Mr. Mr. Scrimmin?
Yeah, I understand. I had talked to him, and he says he didn't want me representing him for the first appearance.
That wasn't in this case, Tony. It was other things.
Yeah.
All right, so we'll go ahead with the hearing, sir, okay?
Okay, and then, Matt can give me a call, and we can see if we can work
He'll
it
get you
out
a court
after
date,
that.
Tony. You're going to represent me, okay?
Yeah, Matt, give me a call as soon as you get this wrapped up today or whatever. And,
They won't even give me access to a phone or a glass of water, Tony.
Yeah. So, sorry about that, Matt, but, I had no notice today. I haven't been retained at this point. You said you were going to handle it initially. That's what we discussed the other day.
No, this was something completely different from this case.
Oh, okay.
Do you understand? It has
sorry
nothing to do with what I talked to you about, Tony. It has nothing to do with what
All
we
right,
talked
this is
about.
what I'm gonna do. He's obviously representing himself, so, I'll
This
just
is
let.
not requesting anything more than take my time and get my ducks in order. That's all.
Yeah.
Okay, so we're gonna go forward with the
You don't
hearing. I've
understand
offered him
what
the
I do.
opportunity to use the public defender. He's refused that. He's refusing you. He's demanding to represent himself. So, sir, you have the right to remain silent. Anything you say can and will be used against you, as I told you at the beginning of this hearing. So, we're gonna conduct the hearing, sir. If you'd like, I can leave you on the phone to listen.
It's up to Matt.
Go away, Tony. I'll talk to you in your
He
office.
said go away, okay?
Okay.
No
good enough.
offense.
I'll talk to you later.
That were his words. Thank you.
Okay, thank you, Judge.
Bye-bye. All right, court does find probable cause. I told you the charges, sir. You heard me tell your attorney.
Your Honor?
Or your prospective attorney.
And Your Honor, and this is regarding probable cause. Your Honor, I know it says attempted felony murder. I believe that's a misbook. Noting the third line of the report, it would appear based on the allegations and the language that the officer uses or the deputy uses in the PC that it should be attempted first-degree murder.
Okay. All right, so, sir, you gotta listen. If you're gonna represent yourself, charge one is attempted first-degree murder. Is that correct, State?
Yes, ma'am.
Okay, count two is ag assault with a deadly weapon without intent to kill. Count 3, 4, and 5, you heard me say before, it has a $25 bond, $1,000 bond, $100 bond, which is criminal mischief, $200 or less, first offense. Count 4, carrying a concealed firearm, and count 5, discharge a firearm in public. State?
Your Honor, on count one, as the charge that I've asked the court to make a finding for, that is a punishable by life offense. Because of that, Your Honor, the state would be seeking a no bond hold at this time, requesting that the court make a finding of proof evident or presumption great for first appearance purposes only under Isaza v. State. Your Honor, relying upon the allegations contained within the probable cause affidavit. If you want, I can make a recommendation on count 2 at this time, or if you want me to wait after you make it. On count 2, Your Honor, I'd be requesting bond in the amount of $50,000. I believe Your Honor ordered no victim contact already?
No, I didn't do anything because I didn't know if there was going to be an attorney representing him.
I understand. Your Honor, I'd be requesting an order of no victim contact, additional release condition of that Mr. Rosengarten not be in possession of any firearms, weapons, or ammunition. If the court does not make a finding of proof evident or presumption great, or if the court is inclined to set a bond on count 1, obviously I'd ask for time to perfect, but I'd also request pretrial release with a GPS monitor. If it's a no bond, then obviously that's a moot issue.
Okay, sir, they're saying that the proof is evident, the presumption is great. Do not talk about the facts of your case. This is the problem that you're in now, that you're representing yourself. So the state's asking that you be held no bond. They're saying the proof is evident or the presumption is great that you be held without bond until further order of the court. What is your response, sir?
Judge Malika, at this time I have no response to them because they're totally out of whack. I can prove without a shadow of a doubt, with clear, concise evidence that my life was in danger at the time, that the man was an undercover police officer, and that they're covering their own ass. So now if you want them to go ahead with this delicate matter, without any further ado, I suggest you do what you think is right.
I'm reading, sir. Give me a moment. Hey, tell me where the proof is evident or the presumption is great here.
Your Honor, I would note the evidence contains that not only did Mr. Rosengarten fire multiple times, but that he also chased him for approximately 300 yards, which not only shows a premeditated state of mind, but also would negate any argument of self-defense, because the allegation is that Mr. Rosengarten, in fact, chased the victim. It also notes, Your Honor, the officer notes that that the alleged victim retrieved his knife in self-defense.
Well, he has a knife now. He denied having a knife, Your Honor. To the police officers.
And I would also note, Your Honor, Mr. Rosengarten admitted to shooting at the alleged victim, specifically stating, I knew I grazed him with a bullet.
What's your position on a self-defense with proof evident presumption great?
Well, first of all, that's an affirmative defense, which can only be maintained by presentation of evidence by the defense, which I would argue, would not legally be considered at a first appearance since it's a non-adversarial hearing. There is, as I stated, Your Honor, there's evidence in the probable cause affidavit to negate a self-defense claim, namely one, that Mr. Rosengarten chased after the victim while shooting for approximately 300 yards, and also the officer's sworn in the officer's sworn report that the victim is the one that retrieved his knife in self-defense.
That is a complete denial of my right to cross-examine this bastard that's giving you a bunch of shit.
All right, sir. Anything further?
Ma'am, I am an expert at what I do. I can shoot from here to 10 feet without...
Sir, please don't talk about the facts of the case.
Okay, ma'am, I can do that. I was former military. I know how to shoot a gun. Can I tell you what this is all about? It's all about their failure.
Sir, please don't talk about the facts of the case.
They're talking about my failure to protect myself, which is exactly what I was doing. They were failing to protect me.
Okay, sir, we're not here for an affirmative defense today, though. We're here for probable cause and to determine if there's proof evident presumption great.
You're here to pass judgment on what the case is all about, Your Honor. If I
It's
can't
just
state
for
my case,
just for magistrate court, sir.
To life, liberty, and the pursuit of happiness. You're already taking away my gun, and you're telling me I have no right to have another gun. But you know what? I'm going to go out and get another one, whether you give me one or not.
All right, sir, I've reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. You're going to be held without bond until no bond on count 1 until further order of the court. This order is without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Sir, you're also to possess no firearms, ammunitions, or weapons, and you are to surrender any to your local law enforcement immediately upon your release. Count 2 is going to be $25,000, or excuse me, court's going to do $50,000 in bond on count 2. Count 3 is going to be $25. Count 4 is going to be $1,000, and count 5 is going to be $100. Thank you, sir. Good luck to you.
I want this man held in contempt. He did not relay my message to you.
Okay. Thank you, sir. Good luck to you. Joshua Ishmael Jones. Ishmael. Okay, Mr. Jones.
Yes, ma'am.
You have DUI, alcohol, or drugs, first offense, $500 bond. Counts 2 through 7, sir, are at $1,000 bond each. So that's $6,000 for DUI with damage to property of a person or another. Count 8 is leaving the scene of a crash involving damage to property. There's no bond attached to that. And it's the same for count 9. Count 10, however, we need to talk about bond. Failure to stop or remain in an accident involving non-serious injury. Count 9 is basically an RLR. It's a learner's driver's license violation. And counts 12 and 13 are 2 violations of probation where you are going to be held no bond pursuant to your division judge's instructions, and that is Judge Joffrey Cohen has ordered that you be held no bond on those 2 counts. Court does find probable cause. Does anybody wish to be heard? Don't talk about the facts of your case, sir.
The state would ask for a $1,000 bond on count 10. The defendant is on felony. Oh.
That's okay. All right, so state, what are you asking for on count 8? I'm sorry, not 8. On 10.
$1,000, Judge.
The state suggests $1,000 on count 10?
Yes.
Yes.
Objection, Judge.
All right, so this is what the court's going to do. Hold on, sir. Count 1 is $499. Counts 2, 3, 4, 5, 6, and 7. $999. Count 8 is ROR. Count 9 is basically an ROR. Count 10 is $999. Count 11 is not for magistrate, and 12 and 13 are no bond. You are going before your division judge service Monday, okay?
Okay, ma'am.
At 9:45 a.m. Good luck to you.
Thank you.
You're welcome. Gregory Telmack.
Mr. Telmack's here present, Judge?
Hey, Mr. Telmack, good afternoon. You have 1 charge of aggravated battery with a deadly weapon. Court does find probable cause. The court's going to order no victim contact, direct or indirect, with the alleged victim with the initials CL, Charlie Lima. You understand, sir?
Let's see. So what do you think?
All right. I believe they still, isn't this the combative situation, or just 1 person was arrested? Yes, Your Honor. The 2 of them? So they both go to the school. What are we going to do with the no victim contact?
Depending on how the court rules on Mr. Laguerre's case, it doesn't appear that's going to be an issue in the immediate future. That being said, we would be ultimately requesting just no direct physical contact.
Those are in the same class.
Well, that's outside of classrooms, no direct contact. And even in the classroom, they don't need to speak to each other. They don't need to be having contact with each other.
As far as clearing up that issue, I believe they share
Is there one of the other jails?
common. Mr. Telemack is pursuing their HVAC program, and business program, and and Mr. Laguerre is studying their HVAC program. So they share no classes in common. So I don't think it'll be a problem as far as they both want to go ahead and avoid each other.
Okay, so no communication whatsoever. They are both allowed. I'm gonna put defendant are allowed to attend the school, same school, okay?
Yes, Judge.
All right, let's talk about bond.
State would ask for 2,500
No, and no
And-
weapons.
and no weapons.
No firearm, ammunition, or weapons?
Yes, Judge.
Okay.
Judge, we're going to be asking for $1,000 bond considering the circumstances by reading the probable cause affidavit, and I believe in. I don't think both. You can look at them as both victims. They both do not want to pursue anything, so I don't know if it's going to get past the case filing stage.
Okay, so what are you asking for?
A straight $1,000 bond.
$1,000 bond, no direct, $999?
Yeah, $999.
Well, he doesn't have a VOP, does he?
No.
Okay, then I'll make it $1,000. $1,000, no direct contact. Sir, you're not to possess any firearms, ammunition, or weapons. And if you do have any, you're to surrender them immediately upon your release to your local police department. Do you understand?
Yes, ma'am.
All right, you see Mr. Laguerre, and I'm gonna tell him the same thing. I don't know if he's sitting there. But if you see Mr. Laguerre, you are to walk the other way, and that's it. No communication with him whatsoever. Do you understand?
Yes, ma'am.
All right, sir, $1,000 bond. Thank you. I'm gonna keep this for this. Clyde Laguerre.
Mr. Laguerre, come on up.
I got this one. No,
Okay,
I got it.
Mr. Laguerre, you are charged with touch or strike battery. $1,000 bond, counts 2 and 3 are probation violations. You have no bond holds. I don't know when you're going before your division judge. Does anybody know?
Those are, it's out of Hillsborough.
Okay, they're out of Hillsborough County. Is that because these 948?
Yes, ma'am.
Okay, you have 948 holds. So,
Judge, the only thing I'm going to be asking for, considering this is a misdemeanor offense, he can't be released until Hillsborough comes and picks him up. They're not going to pick him up and pending. Would you consider an ROR on count 1 so that he could be transported to Hillsborough County?
I think pursuant to the statute, we have to set subtype of bond.
No, that's, no. He can be ROR on count 1 if the
Okay.
court's inclined.
All right, ROR on count 1. Sir, I'm going to tell you, no direct contact, direct or indirect, with the gentleman, Gregory Telemack. You understand?
Frankly,
Oh, yes.
All right, you both are allowed to attend the same school, but you're not to look at each other. All right? No communication whatsoever. Do you understand?
Yes.
Can you do that? No communication if you see him?
You can do it? Yeah. Okay.
All right, no firearms, no possession of any firearms, ammunition, or weapons. You're to surrender any to your local police department if you do possess any immediately upon your release. You understand?
Yes. Yeah.
All right, the court does find probable cause. ROR on 1, no bond on 2 and 3. Thank you. Malik McRae, please. Good luck to you, sir.
Judy.
Okay, Mr. McRae, count 1, possession of weapon or ammo by a convicted Florida felon. Counts 2 and 3 are possession with intent to sell, manufacture, or deliver cocaine. And that's on 2 is cocaine. Count 3 is the same thing, but it's cannabis. So your bond on 2 and 3 is $2,500 and $1,000. And I didn't tell you, on the possession of a weapon or ammo by a convicted Florida felon.
Because of what he was on probation for.
We need to talk. No, that's okay. I just want to make sure he hears me. On count 1, the possession of weapon or ammo by a convicted Florida felon, sir. We're going to have to talk about bond. Count 4 is possession of drug paraphernalia, $100 bond. Counts 6 and 8 are no bond holds for violations of probation. You do have court on April 16th, which is a week from this coming Monday at 9 a.m. And that looks like, I don't know, it looks like Division FB with Michael Rothschild. Anybody want to be heard on count one?
Yes, Judge, the state would ask for a $10,000 bond on count one, and the defendant is on probation for armed burglary with a weapon and grand theft.
Okay. Anything else? Any victim, no victim contact, anything like that? No? All right, state, defense, they're asking for 10,000 on count one.
Yeah,
Judge, we'd be asking for a $2,000 bond on count one concerning being held no bond on counts 5 and 6.
Okay, the court does find probable cause. Bond's gonna be set on count one, $9,999, $2,500 on two, $1,000 on three, $100 on four, 5 and 6 are no bond. Thank you, sir. Good luck to you. Next one is Brandon Drew Turpin, please, and then Jackson Waldrick.
Mr. Turpin, come on up, please.
Judge, on Mr. Turpin's case, just so the court knows that I have a probable cause objection, I don't believe there was a dollar amount listed. They give some over whatever, but they don't list a specific dollar amount.
Do they have to?
Okay. All right, Mr. Turpin, you are charged with burglary of an unoccupied structure unarmed. We need to talk about bond. Count two is grand theft between $300 and $5,000. Is your probable cause objection to count one and two, or just two?
Judge, it's with regards to the grand theft. The what they put here is the only mention of any kind of amount, dollar amount. It says items belonging to the victim with an estimated aggregate value over 300, but they don't specifically say whether it's 301, 10,000, even 299. It's just kind of an estimated. So it could be 299, and we'd be dealing with a misdemeanor at this point.
Okay, so do you have any objection to count one?
No, Your Honor. No.
Okay, State, what do you want to do with count two?
Well, is the court hearing argument, or is already has the court determined that there's no PC, or is the court going to hear?
I'm hearing argument.
Okay.
I tend to agree with them, but go ahead. I haven't heard your argument yet.
Judge, for probable cause purposes, the amount can be estimated, and the officer in this case estimated the amount to be over $300.
With the property that was stolen.
And
Because they state specificity what the property is.
and the PC does state with specificity what the property, what was stolen, each individual item that was stolen, to formulate the estimate.
Okay, the court is going to find no PC on count two. Would you like time to perfect?
For PC for theft. For PC for theft.
And the state would ask that
PC for theft.
Your Honor find PC for the theft charge.
Okay, so PC for petty theft. Count two. And count one, burglary of an unoccupied structure unarmed. Let's talk about bond on count one and count two.
He was just arrested recently. Just asked for.
1 moment, Judge.
Sir, while they're doing that, I'm going to order no victim contact, direct or indirect. Heard me tell a lot of other people what that means today, but I'll repeat it anyway. That means no contact in person, no contact writing, texting, calling, or through third parties with the alleged victim with the initials FOG. And there's no return to the storage facility. Does anybody have an address of the storage facility?
4950 North Dixie Highway in Oakland Park.
And you have a name?
It doesn't.
If you don't, that's fine, I'll just tell them.
I don't see one.
Okay, sir, there's no return to this storage facility, which is 4950 North Dixie Highway. What town?
Oakland Park.
Oakland Park, sir, you understand?
Yes.
All right, so what are we asking for bond, one and two?
Please also ask for 5,000 on 1,000 on 2. He's out right now.
The state on count one would ask for $5,000, and on count two, $1,000. And the defendant is currently out on bond on a grand theft charge.
Okay, Mr. Mr. Romero, 5-1. He has a
Judge,
pending
normally,
charge.
Judge, normally on the third-degree felony, I believe sometimes the state is of the position that $1,000 bond on count one would suffice, and knowing that on count found probable cause only for a misdemeanor petty theft, the standard bond on that is $100. I believe the state, because he's currently out on bond, they want you to take that into account. So, Judge, what we'd be asking you to consider is a $2,000 bond on count one and leaving the standard, we'd ask you to double the standard bond on a petty theft. So we'd be asking for $200 on count two.
Okay, 2,500 on one. Count two, the PC for the petty theft, 200, no victim contact, no return. Thank you, sir. Good luck to you. Jackson Waldrop, please. And
North
then we
Broward,
have Milton Grant. Okay, North Broward. Do we have a Jackson Waldrop?
Don't worry about that.
Jackson Waldrop, anybody
If you
in
don't
North
have it, don't worry
Broward?
about it.
Yes, North Broward is
Okay. Hello, sir. How are you?
Good, how you doing, man?
Good. You have a KPS felony on counts 1 and 2. You have no bond holds. So you're going before your division judge. I don't even know when it is. Does anybody know? On
see,
counts
there's
1 and
nothing
2? Maybe you can look it up, Mr. Farbarek. Counts 3, 4, 5, and 6, sir. You have KPS felonies. KPS misdemeanors. You have a bunch of no-shows. Bond set at 500, 500, 500, 500. Count 7 is an out-of-state hold for your felony. That's also no bond. You are going before your division judge, who is Judge Melinda Brown, on April 12th, 2018, which is a week from this Thursday, sir, at 10 a.m. on the KPS misdemeanors.
Okay.
All right? Thank you, sir, and good luck to you.
All right, thank you.
Next one is Milton Grant, and then we have Andrew Lingley Zeiler.
Grant is approaching, man.
Thank you. And then we have Andrew Lingley Zeiler. Good morning, Mr. Grant. How are you?
Doing so good so far, Judge.
All right, you have counts 1 and 2, KPS traffic, $250 bond and a $100 bond.
Paid on.
And then we have count 3, which is a felony case in front of Judge Barbara McCarthy for KPS not in custody for theft, state fund, failure to remit tax. Bond is set at $3,500. The court does find probable cause. We have bond at 35, 40, 36, 37, 38, $3,850.
Okay.
Can you make that bond, sir?
Yes, ma'am.
You can?
Yes.
All right. Have you been able to call someone?
Nobody know where I am.
All right. Do you have a number that you want the public defender's office to call?
Yes.
All right. Go to the phone to the left. We'll call you in a moment.
Judge,
okay?
actually, I spoke to him earlier. I apologize, I didn't catch who answered the phone.
That's okay.
They indicated that they posted your bond this morning. So I don't know if it's still in the process of going through, but she did indicate that the bond was posted this morning.
Okay. So, sir, take a seat. We'll recall your case. They had to take a break, okay?
All right.
All right. Thank you. We're going to take a break for 5 minutes. Court's recalling Mr. Milton Grant.
He's approaching, ma'am.
Yes, ma'am.
Okay, Mr. Grant, I spoke to confinement and they told me that your bond is being posted. It's in the system, so you should be bonding out within the next couple of hours. Good luck to you, sir.
All right, thank you.
You're welcome. All right, we'll wait for Mr. Linder to get back. Is there anybody else you have at North Broward?
Yes, ma'am, we have one female. 1 second, I'll just give you the name now. Shayna Parker, do you want her to approach?
Sure. That's the last one, so you can go about and do other stuff.
Thank you, ma'am.
I don't have the paperwork on that, so.
You don't have?
Well, she's on the last page of our docket. Oh, that's perfection. Okay. So we gotta wait for Mr. Linder to come back. But,
Understood, ma'am.
okay? So ma'am, you can just stand there unless you wanna sit down. Just be a couple minutes, okay? Can you pull up that case, Chris? Yes.
No, it's in the system.
Let's
It says in
do
the system?
North
Yeah.
Broward, Mr. Linder.
It just hasn't gone through.
It's the last page, it's a 24-hour perfection. It
Here she
is
is.
Shayna Marie Parker.
Yes, Your Honor, the state has nothing additional to provide at this time.
Okay, so tell me what it is, because I don't have any
It
papers.
just counts 1 and 2, no PC, there was no
I see.
evidence for testing.
All right, so ma'am, there's 2 bonds that are set for $4.99 and $99. You are going before your division judge on those 2 tomorrow at 11 a.m. Let's see who MJ is. That's Judge Robert Diaz.
Yes.
She has pending felonies, so I don't really want to resolve her cases, but
Judge, these are felonies anyway. It's a possession of heroin, a possession of cocaine. She should just be
no,
ROR.
on 3 and 4 I'm talking about.
Oh, I'm sorry.
All right, so ma'am, what the court's going to do is the court is going to ROR you.
Okay.
It's on 1 and 2, right?
The possession of heroin, it says on my cover sheet, and the possession of cocaine. Yesterday, we did counts 3 and 4, which are the 2 capious traffic, for $4.99 and $99. Can you bond out on those?
Yes.
All right, if you do bond out, I'm just telling you, this Thursday, Judge Robert Diaz, you have court at 11. You'll be right back here again.
Okay.
All right, do you remember the date? This Thursday, 11 a.m., Judge Diaz?
Tomorrow.
Yes.
It's on the 6th floor of the new courthouse. All right,
And Fort
Deputy?
Lauderdale.
Yes, Deputy?
Yes, ma'am.
Can you write that down for her? Judge Robert Diaz?
Fort Lauderdale, I think so.
Judge Robert Diaz.
Yep. He's the new courthouse. Tomorrow at 11 a.m. Thank you, ma'am. Good luck to you, okay? Ma'am, just let me tell you, just because there was no probable cause, and you were ROR'd on the possession of heroin and possession of cocaine charge, that doesn't mean that they're not going to file charges in the future. Do you understand?
Yes.
All right. Is your address 451 Southwest 135th Terrace, Davie?
Yes.
All right, if that address changes, it's your responsibility in each pending case, because you have more than one pending case, to notify the clerk of the court in writing and tell them. So you have one misdemeanor case and one felony case.
Okay.
All right? You need to contact the public defender's office. Thank you, ma'am. Good luck to you.
Thank you.
Okay,
And
thank
how do
you,
I-
deputy.
You're welcome, ma'am.
We'll see you back at 1.
10-4.
Okay, thank you.
Bye.
Bye. Let me just look. Okay. All right, so next one, main jail, I believe. Andre Lingley Zeiler.
Please here present, Judge of Maine.
Okay, good afternoon, sir. You are charged with a capious felony. It's not for magistrate, actually. You're being held no bond. And you have a capious misdemeanor where you're also being held no bond. You're going before your division judge, Judge Zeller, on April 5th, which is tomorrow, at 1:30 p.m. So you'll be held no bond. Your felony, you can speak to the misdemeanor attorney tomorrow and ask them if they could advise you when you're going to court on the felony. Thank you, sir. Good luck to you. Brock Isaiah McInnes, and then Terrence Turpin, please. Okay, it's okay. Mr. McInnes, you are charged with grand theft between $300 and $5,000. It's a capious, not in custody. Court finds probable cause, bond set at $1,000. Anybody want to be heard with regard to the $1,000? Or anything else?
Yes, Judge, something else.
Yes.
Mr. McInnes, he informed me and he wants me to inform the court. He's currently on probation right now.
Why would he want to inform me of that?
Because he wanted the court to know.
Okay. All right, sir. No return to the Walmart, 555 West Atlantic Boulevard, Margate, Florida. What's he on probation for?
Looks like multiple counts of grand theft, 4 years probation from June 21st of last year.
The reason being is, I believe, Judge, he has no sort of funds to go ahead and post his monetary bond. I'm sure if he wasn't arrested on a 948 hold, his probation officer is probably going to be submitting a warrant. And since he's in custody, he's not going to be going anywhere. And then eventually that warrant's going to hit. He's going to be held no bond.
Okay, so 999. No return to Walmart, sir, okay?
Okay.
Thank you. Good luck to you. Terrence Turpin, please. And then Damian Ross, please.
With regards to Mr. Turpin, this is the same argument that I had with the co-defendant, that there's no specific dollar amount listed with regards to the grand theft charge.
Okay. All right, are you Terrence Turpin, sir?
Yes, ma'am.
All right, sir, you have count 1, dealing in stolen property, $3,500 bond. Count 2 is burglary of an unoccupied structure, unarmed. We need to talk about bond. And that's the same, so 2 and 4 are the same. Count 3 is grand theft between $300 and $5,000. Bond's been set at $1,000. Your attorney, Mr. Farberic, in the courtroom here has given a probable cause argument. We'll talk about that in a second, saying you should be ROR'd, released on your own cognizant on that charge instead of $1,000 bond. Count 5 is petty theft, second degree, first offense, $25 bond. Count 6, 7, and 8, sir, are dealing in stolen property, $3,500 bond, each one. Any objection to probable cause except for count 3?
Judge, I would also, with regards to count 5, I believe that that is the petty theft, that I don't think they gave any, I'm just going back to look, I don't think they gave any dollar amount on the first case. There were 2 different PCs here when I read them.
Correct.
I don't think they gave, if I remember correctly, I don't think they gave any dollar amount. Not even a general one.
Well, they don't have to give a dollar amount for petty theft. Everything has some value.
Unless it's a first or second.
It's a second degree petty theft on the 3rd probable cause affidavit. been to prison for a year and 3 months in 2015 for possession of firearms.
Okay, State, give me the address and I'll return to.
I'll take care of this. 4950 North Dixie Highway in Oakland Park.
Thank you.
And that's the
There's another one for count 6 through 8, another address.
And 1000 West Oakland Park Boulevard in Wilton Manors.
All right, sir. So here's what the situation is on what I'm finding probable cause on. No victim contact, direct or indirect, with the alleged victim with the initials FOG and RN. That means no contact. I'm sure you heard me tell plenty of people, but I'm going to tell you anyway. In person, writing, texting, calling, through third parties, and anything on social media. No contact whatsoever. Do you understand? There's no return to 4950 North Dixie Highway, Oakland Park, Florida, and to 1000 West Oakland Park Boulevard in Wilton Manors. Okay, anybody wish to be heard with regard to anything else? State?
Yes,
As far as the bond amount?
State's gonna go. I'm just,
$5,000 bond on burglaries.
the state would ask for a $5,000 bond on count 2, which is a burglary, and also on count 4.
And you're asking because he has a warrant out of the state of
okay,
Tennessee.
Mr. Farber, we'll start with the probable cause argument.
All right.
Judge, with regards to the probable cause argument, as I indicated with regards to count 3, there's no specific dollar amount with regards. It just says an aggregate value over 300. We don't know how much it is. If it's estimated that close to the line, basically, it could be $299, and we would be dealing with a petty theft situation. So I would ask the court to not find probable cause for a felony grand theft.
Okay, PC for, is it gonna be the same argument?
Same argument. Oh, sorry.
Mr. Linder, that's okay.
Well, your Honor's already ruled on this matter, so.
All right, so I'm just giving you an
No,
opportunity.
no, I know.
Know if you came up with something additional, maybe.
No.
All right, on count 3, PC for petty theft only. So let's talk about bond.
5,000 on the burglaries.
The state would ask for $5,000 on the burglary charges, and the defendant has a failure to appear in. He has an open warrant in Tennessee from 2014. From 2015, I apologize. Traffic-related matter. In 2015 in Florida, out of Okeechobee County. He served a year and 3 months in prison, and that was on a gun charge of concealing possession of firearm by a felon.
All right, what are you requesting on bond for count 3, since I only found PC for petty theft?
$1,000.
You're asking to keep it at the same
And
as
yet-
grand theft?
And the defendant has, oh, yes, Judge.
And he has numerous priors out of the state of Tennessee.
And he has numerous priors out of Tennessee.
Okay. Mr. Romero?
Judge, it's being Mr. Turpin. He's been here in South Florida for 3 years now. He's 34 years old. He's currently working. He works for a company called Epic Productions. He's a state head. He's been doing that for about 3 years now. It depends on the type of assignments he's given, but he can make up to about $400 a week. He lives with his girlfriend in Oakland Park. They share an apartment. The person he's going to be contacting to help post bond is his girlfriend, who's a waitress. So from what he tells me right now, she can't afford anything. Since he has a valid address, these are non-violent offenses, Judge. Mr. Turpin's going to be requesting to be released on standard pretrial release on all 8 counts, Judge.
And Judge, the defendant also has a 2016 felony petty theft in Broward.
All right, count 1 is going to be $1,000 bond. Count 2 is going to be $1,000 bond. Count 3 is going to be $100 bond. Count 4 is going to be $1,000 bond. Count 5 is $25, 6, 7, and 8 are gonna be 500, 500, and 500. That is a total of 1, 2, 3, 4, 4,500, 4,600, and $25 in bond, GPS level 2. Thank you. Damian Ross, please. And then Watson Etienne. Okay. And then what about Watson Etienne, Mr. Romero?
Mr. Etienne is the first team. Come on up, Mr. Etienne.
Okay, and after Mr. Etienne, we have Philip Dwayne Littlejohn.
This is when you should be putting that.
Hey, are you Mr. Etienne, sir?
How you doing, Your Honor?
Fine, thank you. Sir, you have count 1, trafficking in heroin between 14 and 28 grams. Bond is set at $250,000. Count 2 is trafficking in cocaine between 25 and 200 grams, $15,000 bond. Count 3 is trafficking in oxycodone between 7 and 14 grams, $75,000 bond. Count 4 is possession of cannabis, 20 grams or less, $100 bond. And counts 5 and 6 are not for magistrate. Those are basically civil traffic infractions. Disobey or avoid a traffic device. And count 6, obstruct traffic. Court does find probable cause. Want to be heard with regard to bond? Mr. Romero, I can't hear you. You muted
I
yourself.
apologize.
You muted
Judge,
yourself.
in speaking with Mr. Etienne, he's been residing in South Florida his whole entire life. He's 27 years old. He went to school down here. He graduated from Fort Lauderdale High School, class of 2008. He did attend college. He studied business. He didn't complete. He's hoping one day to try and complete his studies. And having said that, he's currently working. He works for OU Ground Maintenance. He's been employed with that company now for about 5 years. He gets paid approximately $1,000 bi-weekly. He rents an apartment. He doesn't own any sort of home or anything like that. He lives in Coconut Creek. He has a year lease. He's paying approximately, how much is he rent? $1,250 a month. He lives there by himself. He does have family that live in the state of Florida, specifically his sister. His sister rents an apartment, doesn't own home, and she's a union, gets paid hourly. That's the person that he's going to be contacting to help post his monetary bond. Like I said, he has no money in the bank. He does own property. He has a Toyota Camry. It's a 2015 model. He's financing it. He pays about $300 per month, and it has approximately 41,000 miles on it. When I asked him what's the resale value on it, he believes it's around $12,000. Judge, what I'm going to be focusing on is on counts 1 and 3. There's no way he's going to be able to come up with $250,000 on count 1 and $75,000 on count 3. Considering his financial resources, he does have priors. I believe his last contact with the system was back in 2013, Judge, as far as picking up offense. So we'd be asking you to reduce the monetary bond on count 1 from $250,000 to $50,000, and on count 3 to reduce it from $75,000 to.
We lost you. All right, let me turn the system off. Here's the number for. Oh. Here it goes. All right, I can hang up on Craig.
$1,000, but we didn't hear count 3. Yeah, they're rebooting now, so. 15, 25, okay.
You wanted 50 and.
Oh, did I keep seeing the lights go out in the back, so. No. Oh, okay.
Craig, if you're listening, the electric went out at the main jail, that's why it went off. Okay, so what were they asking on 3? No, I know, but what did he ask for on 3? So 50 and 25, okay. Is the electric on yet? All right, Craig, if you're listening, can you reset again? I've seen the lights flicker. All right, so you know what? Tell them we're gonna reset these for this afternoon. Why wait? I mean, it's 11:48. All right, so we'll reset these 3. All right, tell him, thank you, everybody, whoever can hear me, we'll be back 1 o'clock.
Danny's, is it? He bonded.
Okay, so let me do him, Sean who?
Sean, is it Danny's that look like a?
Danny's.
Danny's?
Okay, can you tell him Sean Danny's bonded? Last person.
So the only one is Philip Littlejohn. We
No,
reset
we have
She's gonna reset
Watson,
these. I don't know if you
Etienne,
heard.
the one that we
So
were
what I
on,
do is what I
and then Philip Littlejohn.
Set them, reset them again?
1 PM today.
Yeah.
So I'll let you guys go. Don't you want your lunch or?